Okay, wonderfully, our IT director solved it very quickly for us. And we are live on YouTube. I'm going to be sending the link right now. Director solved it. And I'm just not speaking due to the feedback. I'll be with you in just 1 second.
Mr. Hearing Examiner, I also believe that Miss Clark is in the waiting room.
Okay. Good morning, everybody. Can everybody hear me? This is Kevin Gedko speaking.
Yes, we can, Mr. Gidko.
Great. We were able to solve that problem with the assistance of IT. And we are now on YouTube, and the link has been sent to Ms. Kippenbrock to post to our website. And I just need to gather myself for understanding where it left off yesterday, and then I'll be able to proceed. But I need a minute or two just to get my windows rearranged. I gave somebody control of my computer for a few minutes there, of course.
Okay, that sounds great. I'll get the hearing on the record here and then address some of those points we discussed previously. So good morning, everybody. The time is 9:14 in Santa Fe, New Mexico. This is day 3 of our hearing in the matter of Southwest Public Service Company's application for revision of its retail rates under Advice Notice 341, particularly the evidentiary hearing on the comprehensive stipulation in this case, which is case number 25-00079-UT. I'm hearing examiner Schaefer, joined by hearing examiner Gedko for the New Mexico Public Regulation Commission. I also note the attendance and participation of Chairman of the Commission, Pat O'Connell, who may be raising thoughts or questions throughout today's hearing. I also, before we begin our hearing, now that we're on the record, I wanted just to address two small procedural elements. One is that SPS, or that the hearing examiners have taken administrative notice of the application, and SPS will be uploading that to the Dropbox momentarily for inclusion into the evidentiary record. The other item I wanted to mention is that OPL will be preceding New Mexico Large Customer Group in the presentation of witnesses. So that's another issue that I just wanted to have stated formally for all of our situational awareness. So with that, I believe, yes, Mr. McMillan.
Your Honor, I believe you got that backwards, just to make the record clear. Was that NMLCG was going to flip over OPL and go first?
That OPL would go first.
That NMLCG would go first and then OPL was I believe what we had discussed.
Okay, yes, that is correct, Mr. McMillan. Thank you for the clarification. There's a lot of details and parts to keep track of. Much appreciated. So New Mexico Large Customer Group will be preceding OPL in the presentation of witnesses, and that was stipulated by both the parties without objection. So with that being clarified, if we're all ready to proceed, I believe that we're continuing with the presentation of SPS witness, Ms. Naomi Koch. Ms. Koch, good morning. Can you hear us?
Yes, I can. Can you hear me?
Yes. Thank you again for being with us. I believe you're still under oath that was administered to you yesterday by our court reporter, Mr. Lee. And unless there's any other further procedural matter, I believe that you are that hearing examiner Getko will continue with his questions for you. Thank you so much, Ms. Koch.
Good morning, Ms. Koch.
Good morning.
So where we left off is I was asking some questions about production tax credits and discussing, how long they might not be able to be transferred for, and therefore carrying costs. And to paraphrase, I had said, would it be? I was discussing the possibility of setting a limitation of the amount of time that production tax credits could exist within the SPS system and accrue carrying costs. And so I think a simple question would be, would SPS be opposed if a time limitation were added to the stipulation to limit the amount of time through which SPS would have the right to accrue carrying costs on those because of the inability to transfer those or apply those to tax liabilities?
I, in my role, can only respond to what the IRS potentiality is. So it was the 20-year carry forward that I mentioned yesterday for the deferred tax asset. If we decide to carry it forward, or the 22 months, if we that's at the most, if we intend to sell the credit. If the question about whether we'd modify the stipulation, be willing to modify the stipulation, that wouldn't be my area. That would be more of a Zoe Lee's question.
Are there tax liabilities? So my understanding is that since Hale and Sagamore started accruing production tax credits in 2019 and 2020, there are still, those cannot be transferred. Those have to be applied to tax liabilities. And there's still Hale and Sagamore production tax credits that you've been unable to apply, and you aren't allowed to transfer them. Did I understand that correctly yesterday?
In part, yes. But just as a reminder, the Hale and Sagamore credits generated in 23 or after, we are selling those. It's the credits, as you noted, from 19 and 20, beginning in 19 and 20, earned through 22 that we are carrying forward.
So the first of those production tax credits would have come on in 2019.
Correct.
And there's a possibility that here in 2026, there are still production tax credits generated by either Hale or Sagamore that have not been applied to a tax liability. Is that a correct understanding?
Yes.
And if you had to make your best estimate as to when you would be able to apply those to some tax liability of the Excel system, what would your best estimate be for when you would be able to apply those?
I am not sure. And the reason why, I think you would ask the question on Monday about how we track PTCs. We do track them with incredible detail. However, I just know that we're not going, off the top of my head, I just know that we're not going to be current at the Excel energy level for several more years. But I don't know specific of that carry forward what relates to Hale and Sagamore. Even though we could track it, I just don't know it off the top of my head.
Okay. Are you familiar with case number 2400270-UT, which was a fuel clause proceeding?
I assisted the witnesses in that case with some of the discovery, but I was not a witness in that case.
Okay. In the final order, there's an annual report that SPS is ordered to file. It hasn't been filed yet. because we haven't reached a year since since that final order was issued. I think October 30th, 2025 is when it was issued. With a bit of work, would you be able to produce a report in response to a bench request that provides the information that's required to be provided in that report, and ensure that it includes details with respect to what resources generated those production tax credits for the SPS system?
Could you clarify what the report is?
What I have here is it says SPS's annual report on the sale of PTCs, and this is associated with the SPS self-build solar projects. And so if I remember correctly, Hal and Sagamore are wind. And so that's why it can't be an exact duplicate of this. So I'll start reading again. SPS's annual report on the sale of PTCs associated with the SPS self-build solar project shall provide for the preceding calendar year by SPS self-build solar project, SPS's monthly accounting for generated PTC value, PTCs transferred, and associated transfer costs incurred related to those PTCs transferred. So I would want that to extend to wind projects as well. And then I would want it to contain information as to the date on which those production tax credits that remain on the books were generated.
Yeah, I think that's reasonable. We could add at least the Hale and Sagamore, and that's, if there's other layers you wanted to add, certainly we can do that.
Great. Well, then let's consider that a bench request. Make it clear that will be for all production tax credits, however generated, and proceed from there.
Could you clarify though, the 24K, that's, we have that in writing for this, through what period would 25 be reasonable? That would show 3 years of credits, or?
So
I mean, you can certainly do
I'm
it
sorry, I didn't
today.
understand how the 3 years related to the 2025. I'm sorry.
It does. It's just that's like the question, the 24 report is asking for the PTCs generated and then sold. And so I was just thinking if you wanted, like, I'm just trying to figure out what time period you want.
I'm interested mostly with my understanding of what to be interested in at the moment. To production tax credits that were generated in 2025 and prior.
Sure.
That have not yet been transferred. And I speak slowly because I've learned from you that 2025 production tax credits generated are normally transferred around October of 2026. And so I don't want to skew my understanding of the data because I'm seeing production tax credits generated in 2025 and inappropriately make it say, oh, that's a pretty big balance that hasn't been transferred, because you've already testified to there's no remaining PTCs generated from 23 or 24 that remain on the books. And so does that help clarify how to put that report together?
It does. And I'll further clarify, when I mentioned 22 months as the max kind of transfer period that we would hold a credit before we transferred, that really is the max. So I think I understand your request. And I'll further note, like, we can provide the credits earned in 23, 24, 25. And when those either have been or are expected to be transferred, that's very manageable. For the 2019 through 2022 Hale and Sagamore, we can work with Allison's team to show what the regulatory carry forward is on that, like what the cost of service view of that is. That's very doable.
And just to be clear, I'd want to see from 2019 through 2025, the PTCs that remain on the books, the date they were generated and the resource that generated them, and have them not be limited just to Hale and Sagamore, but to any renewable energy resource that generated those PTCs.
You bet. It's just that the Hale and Sagamore, those are the ones that are pre-Inflation Reduction Act. That's why I called attention to those, but I think that's a manageable request.
And I say it that way because I'm ignorant as to whether there's other resources that generated PTCs prior
No
to
worries.
the IRA, and I don't know that answer, so. Thank you. Okay, with as settled as my brain is at the moment, I think that is all of the questions that I have. Thank you.
Thank you.
Thank you, hearing examiner Gecko. Thank you, Ms. Koch. Ms. Hardy, do you have any follow-up questions for Ms. Koch?
My only question was regarding the bench request, and I'm not sure how long that information would take to put together. And so I was hoping Ms. Koch might be able to tell us so we can give your honors an idea.
I mean, I hope to take at least today to get it together. I might need a little bit of tomorrow to pull it together, but that's manageable.
Okay, thank you.
Thank you,
I've
Ms.
just-
Hardy. Go ahead, Mr. Hearing examiner Gecko.
I'm sorry, Hearing Examiner Schaefer, maybe you already admitted, I got a little notice that there may be somebody in the waiting room, but maybe you already took care of it.
I did, yes. Yes, I did. I did.
Thank you.
Well, with that, Ms. Koch, thank you on behalf of the commission for all your time and effort with regard to this proceeding, and you may be excused.
Thank you.
Thank you. Okay, Ms. Hardy, I believe we're ready for SPS next witness.
Yes, Mr. Examiner, thank you. Our next witness is Ms. Nicole Doyle.
Thank you. I'll just say also while we're waiting in this little brief period for everybody's situational awareness that SPS uploaded earlier this morning the response to the evidentiary hearing second bench request. So that has been filed, and Ms. Hardy, if you would at a certain point like to move for its admission into the record, we can do that as well. And I just wanted to mention that for notice purposes so that all parties have an opportunity to review that response.
Sure, thank you. I believe Ms. Doyle is on. Ms. Doyle, if you could please turn on your camera.
Yes, I see Ms. Doyle now on the screen. Ms. Hardy, thank you. Good morning, Ms. Doyle. I'm hearing examiner Schaefer. Can you hear us?
Yep, I can hear you.
Okay, thank you. I'll just have the court reporter swear you in, and he will just take care of a few things and then swear you in once he's ready.
Sounds good.
Ms. Doyle, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, ma'am. Go ahead, please.
Thank you. Ms. Doyle, can you please state your name for the record?
Yep, it's Nicole Doyle
By whom are you employed and in what capacity?
by Excel Energy, and I'm the Director of Corporate Accounting.
And have you prepared SPS Exhibit 27, which is your direct testimony?
Yes.
And since Exhibit SPS 27 has been admitted into the record, I have no further questions for Ms. Doyle. She's available for examination from the hearing examiners. Thank you.
Thank you, Ms. Hardy. Hearing examiner Gecko.
Good morning, Ms. Doyle.
Good morning.
Good morning. I had a question for Ms. Scheller yesterday, and I've been informed that the information is contained within your testimony. And so in the direct testimony of Ms. Scheller, it's stated that the vast majority of the technology services capital projects I address are projects that are implemented across Xcel Energy and affect all of the operating companies. And that's tied to $106.6 million that's assigned to New Mexico for both technology services and ESS physical security capital additions. And could you point me to both where it's shown how you allocate the technology services capital projects across the subsidiary companies of Xcel, and I don't know whether you point to that first or not, but maybe a brief explanation of how that process works. I'm sure it's pretty clear, but I don't know it.
Yeah, I can give a brief explanation. My testimony that I've submitted around cost allocations is a little more on the O&M side.
I'm sorry, ma'am. I'm sorry, you're talking too fast.
Oh,
My
sorry.
testimony that I submitted.
Yeah, that I submitted is primarily related to our O&M costs. However, we use the same methodologies when allocating these IT costs. So the methodologies that I have listed in attachment 6 and 7 of my testimony describe the different methodologies that could be used to allocate the IT costs.
Okay. Just 1 second. Let me make a note. If everybody just so attachment 6 and 7. You don't know off the top of your head what PDF page that is, do you? I see attachment NLD 4. All right, I'm getting
Let me
there.
find it.
There we are. Okay, page 1. So there's a cost center description, description of services provided, allocation method, assets / revenue / number of employees. And I'm going to keep scrolling down quickly. It's a 28-page document, number 6. One of them is according to electrical vehicle plant, electric transmission plant, gas distribution plant. So, and then 7 is more detailed. Is there an easy way to differentiate between technology services versus ESS physical security in these tables that's clearly defined?
There isn't an easy way. Technology services can use many different of those allocation methodologies that are defined in those tables. So based on what the project is, whatever the most cost causative methodology is what would be used to allocate the costs to SPS.
Okay, and do you know where the testimony is that explains which is the most cost causative methodology that was used to allocate these costs to New Mexico in this application?
I do not.
Okay. And do you know who testifies to what has been termed the technology services and ESS physical security allocation as opposed to O&M, which you differentiated from O&M? Do you know where I would find testimony regarding the technology services and ESS physical security capital additions?
I don't know that we have testimony that specifically lists out the allocation. There's going to be different methodologies for the various projects that make up the dollars that are in witness Schiller's testimony, but they are going to be based on the allocation methodologies that are outlined in my testimony.
Okay. It's not worth asking questions about the allegation methodologies. That's not something that I could never keep that in my head. I can't imagine that's in your head either, is it? How they function, how each one of those functions.
How each functions?
Yeah, like how one of those allocation methodologies functions. Right.
I mean, each one has a description in kind of the attachments on how we gather or what statistics that we use to calculate the allocations. And those are what are applied to our just our master data to establish the dollars.
Okay. Okay. I really appreciate you pointing me to that, those places in your testimony. And those are all the questions that I have. Thank you.
Okay.
Thank you, Hearing Examiner Gecko, and thank you, Ms. Doyle. Just for due process purposes, because Ms. Doyle is a bit of an unexpected witness, I wanted just to check with staff to see if they had any cross-examination for this witness. Ms. Amer, Mr. Elliott. Okay, thank you. The record reflects a nonverbal no from Mr. Elliott. Thank you.
Mr. Examiner,
Yes, Ms. Hardy.
I had a couple of follow-up questions in response to Hearing Examiner Gecko's questions, if I may ask them.
Of course, yes, please proceed.
Thank you. Just to be clear, Ms. Doyle, does Ms. Scheller's testimony cover the IT and security capital additions?
Yes.
Okay. And if you could turn to page 314 of your PDF, I believe it's that is an attachment NLD7.
Okay.
And is cost center 200154 the customer service IT FERC account 903 description?
Sorry, there's a lot of pages.
Yes, there are.
Yeah, okay. Well, can you repeat your question, please?
Sure. Is cost center 200154 the customer service IT FERC account 903 information?
Yes.
And then if you turn to page 317, so it should be 3 pages later,
Yeah.
is cost center 200157 also the customer service information technology FERC account information?
Yes, it is.
Okay, thank you. Those are all of my questions.
Thank you, Ms. Hardy. So no cross-examination and follow-up questions have been asked. Ms. Doyle, thank you so much for your time and participation in this case. Much appreciated. You may be excused.
Thank you.
Okay, I think we're ready for your next witness, Ms. Hardy.
Thank you, Mr. Examiner. SPS's next witness, Mr. Paul McGregor. And if you can just give us a moment, I believe he is in the witness room, and his testimony will be presented by counsel Patrick Zomer, who we did receive the Pro Hoc Vice admission order on. So thank you.
Yes, thank you. Mr. McGregor, I believe you're on. Can you hear me?
Yes, I can, sir.
Great. Thank you for being here with us this morning. My name is Patrick Schaefer. I'm one of the hearing examiners on this case. And we will first get you sworn in by our court reporter, who will reach out to you here once he gets situated.
Thank you.
Thank you.
Mr. McGregor, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you. Go ahead, please.
Go ahead, Mr. Zomer.
Thank you, Your Honor. Good morning, Mr. McGregor.
Good morning, Pat. How are you doing today?
I am well. Could you please state your name for the record?
Certainly. My name is Paul McGregor.
Can you please identify your employer and title?
Yes, I'm employed by Excel Energy, and I am the Vice President of Wildfire Risk Management.
And Mr. McGregor, your direct testimony, which has been marked as Exhibit 24, has already been admitted into the record. So Mr. McGregor is available for examination.
Thank you, Mr. Zomer. I see that staff had 10 minutes allocated for cross-examination of Mr. McGregor. Mr. Elliott, Ms. Amer, is that still the case?
We have no questions for Mr. McGregor.
Thank you. Thank you, Mr. Elliott. No cross-exam, no redirect then, and I would just ask if hearing examiner Getco has any questions for Mr. McGregor.
Yes, I have a few questions. Good morning, Mr. McGregor.
Good morning, Mr. Getco.
Good morning. I've reviewed it. Can you explain, does your role include developing wildfire mitigation plans as well as handling cost allocation for the costs to implement those plans to Excel's subsidiaries? Maybe I intend that to be an open-ended question for you to explain your role.
Certainly. In my role as Vice President of Wildfire Risk Management, I do have a number of functions that looks at how we prepare the utility for increase and extreme fire weather conditions. So that would be meteorology, my situational awareness team, risk and data analytics, as well as the planning and implementation of mitigation programs. Along the way, we do prepare the wildfire mitigation plans, and I believe the one attached to this case is the one that was filed in December of 2024. With regard to the cost allocation, I do work with my finance team to make sure that we categorize and file our costs in the correct allocations, and then they are spread across the company to the various subsidiaries of Xcel Energy by way of some of my partners in our business area finance group.
Okay. Are there costs that are shared system-wide and that are just evenly distributed across the different subsidiaries, or do you know that answer?
That's not really my specialty, Mr. Gedko, the allocation.
Okay. And so the most recent plan you said was filed, the one that's attached to this case was filed in December 2024. Is that correct?
That is correct.
Through when does that plan extend?
That plan was the first plan that Xcel Energy filed proactively in the state of New Mexico, while we've been working with the PRC as they've been going through the development for any potential rulemaking. So that plan is live until it is superseded by any additional plan at the direction of the PRC.
Got it. Okay. And I'm sure there's people in this building that know a lot more about this than me. There's been good work done on it, I know. So I appreciate your patience with my questions. Was there an internal plan prior to this plan coming to fruition? The one that
Not
was
to
filed?
my knowledge. Sorry if I spoke over you there. Not to my knowledge. I joined Xcel Energy in September of 2024 and picked up a lot of the work that was already ongoing. Xcel Energy had filed a wildfire mitigation plan in the state of Colorado in 2020, and then again in June of 2024, which I picked up and adopted as my own. The subsequent filings or the subsequent publications in New Mexico and some of our northern states' power, were done under my direction. And we have since then, we are working to file a wildfire mitigation plan in the state of Texas at the end of this month in alignment with the rulemaking set by the PUCT.
And did you pick up the work on any other plans or just those two Colorado 2020 and Colorado June 2024?
Just to be clear, I had nothing to do with the June 2020 plan well before my time. I did pick up and adopted the testimony for the 2025 Colorado WMP that was filed on or around June of 2024.
Okay, and then you mentioned a Texas plan that's being filed. Was there a prior plan to that?
There was not. Xcel Energy through SPS, Southwestern Public Service, had published on its website a very similar wildfire plan to the one that you're seeing for New Mexico for the Texas area. And then upon receiving guidance through the rulemaking by PUCT, we will file our next mitigation plan on or around August 1st of this year.
Okay. With respect to New Mexico, can you, as an open-ended question, explain to me the progress that's been made with the implementation of the plan that was filed in this application thus far to date?
Yes.
Thank you.
Yes, certainly I can help you with that. The way our file is planned, there are multiple layers of defense, which we've laid out in my testimony. It really starts with our meteorological capabilities under what we call situational awareness. And that has been building out the capability in-house with fire scientists and meteorologists to be able to predict and forecast fire weather conditions as they impact our service territory. Now, for Xcel Energy, that's an 8-state service territory. So I have one group that performs this function for all of our 8 states. We have also developed some situational awareness capabilities with the deployment of proprietary weather stations and artificial intelligence cameras, as well as our wildfire command center that allows us to monitor those cameras and also monitor any alerts that we may receive from fire agencies, etc. So we have stood all of this up. We've also built the risk management and data science capabilities in-house at Xcel Energy so that we are not relying on external consulting support solely. So we built that in-house, developed that capability, and that is in place as we speak today. We've also worked to develop a number of wildfire mitigation plans where we will implement a number of mitigation programs. We need the situational awareness to understand the where and the when these fire weather conditions may impact us. And then we look at what we actually do about it, whether that be physical mitigations that we call system resilience type investments where we're strengthening and replacing assets, as well as operational mitigations where we can change the settings on our system to account for that extreme fire weather with fast trip settings, reclose blocking, etc. That allows us to operate our system safer with these extreme and elevated conditions. Lastly, we have developed what we call a public safety power shutoff program, and that would be the proactive de-energization as a mitigation of last resort when fire weather conditions are so extreme. And I believe we did enact a PSPS in March of 2025 that did impact the eastern New Mexico area around Tucumcari and some of those local communities.
Thank you. When you say that you've stood up the assets for situational awareness, cameras, AI, does stood up mean that they're actively being monitored currently, that those systems are in place and functioning?
Yes, that's correct. With regards to the weather stations, I believe we deployed about 10 weather stations in New Mexico in 2025. So just for the tracking of the costs, that would be in that linkage part of our time period. So it would be a 2025 cost. The purpose of implementing these proprietary weather stations is it gives us better granularity to weather conditions and environmental conditions in proximity to communities and our assets. Off the top of my head, we deployed approximately 15 artificial intelligence cameras in 2025 again, and they are up and operational. They pipe into our wildfire command center, which is monitored 24/7, as well as providing that feed to various first responders and offices of emergency management to monitor their own communities.
Great. I think I only have a couple more questions then. With what I understood, and I don't think it's the proper understanding, is I understood that situational awareness is used to make decisions as to certain programs, both physical mitigations and operational mitigations, to put into practice. And my head went to, is there also, I think I understand that it gives you that granularity, like what needs to be put in. But am I correct to understand that certain physical mitigations and operational mitigations aren't put into place just on a general review of the physicality of the system? You know, driving around, looking at it, understanding whether there's brush near. Can you explain whether there's actions taken in that respect and how those have been tied to physical mitigations and operational mitigations that are already in place?
Yes, certainly. There's quite a lot to unpack there, Examiner Gedko. So let me take them through, and please feel free to readdress if I don't cover them. With regards to operational mitigations, we need to understand where fire weather conditions may exist. And then more importantly, we need to understand when those conditions prevail from a temporal component. We do that using our meteorology and fire science capabilities, as well as a number of subscription services that allow us to understand the material and environmental conditions in an area at a particular point in time. That helps us inform our operational mitigations, where we may change the protection settings on our electric distribution and transmission system every day. So we're doing that a day ahead, looking a day ahead at what the weather conditions may prevail, as also looking into 5 days or so in the future so that we can prepare ourselves. When it comes to the physical mitigations, we're using a similar approach, but a slightly different set of models, where we're looking at what the assets and what the environment might look like in the future. So these are what we call our planning models. And that would help us inform how we're going to harden the system or make the system more resilient, i.e. safer, and have better reliability capabilities for our customers and communities.
Great. How far, I mean, it's going to always be an ongoing process. In things that you want to implement, how far along on a percentage basis do you estimate, rough estimate, within 10 or 20% that you think what you've achieved in your mitigation in areas that affect SPS's system? And I think that would include both New Mexico and Texas, since New Mexico side is affected by what might occur on the Texas side.
And that's correct. Thank you for recognizing the interrelation between the two states. Our plan for SPS is obviously across the system, so that includes both New Mexico and Texas. I would say the majority of our investment started in 2025, and it would be a multi-year plan. I couldn't put a percentage on them straight away, but we do have a plan in place for the deployment of our weather stations, our cameras, and that's a multi-year outlook. There's also the system inspections and the system repairs and the system hardening work that, again, is a multi-year plan to upgrade the assets, change out those assets that for larger assets, the replacement of expulsion fuses and expulsion type equipment. So this takes a long time, and we have a multi-year plan in place for that. The majority of the hardening work would be in another of my colleagues' testimonies. I believe that's Casey Meeks for distribution and Corey Woods for transmission. They can talk to the specifics of how they operate their system, but I can certainly help you with the overview.
Okay, and by when do you expect to have the weather stations and AI fully implemented?
I believe these were on 3-year plans, but I would need to check and get back to you on that one. The purpose of this particular rate case was the future year. So that's really that December 2026 through November 2027 period. And I believe the numbers that you're looking for are in the latter pages and the tables of my testimony. I could get them in front of me, or I could point them to you if that would be helpful.
I think I can find them. I don't want to hold you up for too long. It's, part of this is just to Then two more questions. So I've seen this with meters and you know, advanced metering infrastructure, that plans get laid out in a physical location. You know, you move across the state with teams, across the service territory. Where have you prioritized the initial investments to implement this plan geographically, and you know, if you have, and so from where have you started and on SPS's system, and where are you progressing to?
Yeah, that's a great question. Thank you for that. And one of the things we did do was we created what we call our risk tier maps. Well, that was where we used a framework and we used an external consultant to help us build these maps because there were none in existence for New Mexico. And we developed these tier maps. So just to clarify, tier 3 is the highest level of risk. Tier 2 is moderate and tier 1 is low. Now, fire can propagate pretty much anywhere across those tiers, so it's not zero when you're in low. It still has a potential. We prioritized the initial work for SPS. It complemented the system resilience plan filed in Texas, and it complemented that so that we can have efficiencies when deploying that work. We started with our tier 3 assets, and then we would move to our tier 2 assets. That's what we would call our high fire areas, those tier 2 and tier 3 areas. And that's also where we're monitoring and deploying operational mitigations on a daily basis.
Okay. I got confused there just on one thing. You said that you did it in affiliation. That's not the word that you used, with a system resilience plan in Texas. And you also said that you prioritized tier 3. How do I create a Venn diagram out of those two statements?
So the system resilience plan in Texas was laid out to basically on the basis of resilience as well as safety and reliability. That's a large amount of our circuits. So when we prioritize the work for that plan to generate efficiencies for our crews in performing work at a circuit level, or at least a segment level on that circuit, the informing component for wildfire was the fire tier that it was in. So if it was a tier 3, it received priority.
And so have you, you've done work, of course, then on tier 3 areas in alignment with that system resilience plan in Texas, correct?
Yes, and also in New Mexico.
That was my question, to make sure I don't misunderstand. And if you had to, in the test year, where do you think the balance of your work will be focused? If you had to differentiate between the two states?
I don't have that information in front of me, but what I can say is that for New Mexico, there's about 2,200 miles of distribution overhead conductor that is in the tier 2 and tier 3, over a total of about 4,800 miles. So that's 46% of the system is in these high fire tiers in New Mexico. That's the area that's receiving the initial treatment as we're looking at our inspection plans and the deployment of what we call EPSS, Enhanced Power Line Safety Settings, which gives us that ability to toggle the safety settings and the protection settings of those circuits in elevated fire conditions.
Okay. And then what we've seen in kind of rating agencies and such is that, and this is beyond just the mitigation plan, but it's an important part of it, that there's starting to be a calming down of an understanding that good efforts are being made, which is, I think, a compliment to you. If I have to make an off-the-cuff decision, how do you feel about where you stand during the future test year with your measures? Do you feel like you have pretty good measures in place to mitigate? Of course, the risk always exists, even in tier 0, tier 1. But how do you feel with where you stand and with respect to where you would ultimately like to end up?
So where I'd ultimately like to end up is that we can put an end to catastrophic fires, and that would be across the country. Obviously, we're seeing changing climate conditions moving across the country. What started in California, we're now seeing moving across all of the country, particularly the West. For New Mexico and Texas, that can't be left out. The fire risk does exist. We're seeing longer summers, hotter summers, drier summers, and as a result, we need to be proactive in getting ahead of this wildfire concern. I don't think it will ever end, because we will continue to find areas as the public expands into what we call wildland urban interface. So people are moving into these areas, and we need to be able to protect those communities. With regards to the work that we are doing, we have made a good start, and we will continue to develop our understanding. When I say that, when we develop our understanding of wildfire risk, it may mean updating the various models, updating the fuels layers, which is the vegetation, updating weather conditions that are more recent conditions to give us an idea of where and when that risk might be in the future. That may change and grow some of the plans for hardening and for operational mitigation. So it's a continuing process.
Okay. I appreciate you taking my questions and efficiently informing me of your plans, etc. Thank you.
You're welcome, Mr. Getko.
Thank you, Hearing Examiner Getko, and thank you, Mr. McGregor. I'll just ask Mr. Zomer if he has any follow-up questions for the witness.
No follow-up, Your Honor.
Thank you, Mr. Zomer. So with hearing examiner questions having been asked and no cross-examination from the staff counsel, I will then excuse you, Mr. McGregor, and express my thanks for your diligence and participation in our proceeding. Thank you so much. You may be excused.
Thank you, Mr. Schaefer. Thank you, team.
Thank you. Good luck. Okay, so making our way steadily down the list of SPS witnesses, Ms. Hardy or Mr. Zomer, I'm not sure who you will be calling next, but I believe we are still waiting on Mr. Gable and Ms. Brennan. Is that correct?
Mr. Examiner, our next witness is Mr. Gable. Ms. Koch had adopted Ms. Brennan's testimony.
Oh, okay. Sorry about that. Just going to clear that up. Excellent. Okay, so we're at SPS's final witness for now.
That's correct. And SPS calls Mr. Justin Gable. I believe he will be joining momentarily.
All right.
Good. Yes, good morning, Mr. Gable. I believe we can hear you.
Good morning, Hearing Examiner Schaefer.
Good to see you again. Thank you for taking the time. We're going to go ahead and get you sworn in. The court reporter will reach out to you once he's had a chance to get situated.
Okay.
Thank you.
Right.
Good. Yes, good morning, Mr. Gable. I believe we can hear you.
Mr. Gable, would you please raise your right hand? Would you solemnly swear the testimony you're about to give, no matter now pending, will be the truth, the whole truth, nothing but the truth?
Yes, sir.
Thank you. Go ahead, please.
Mr. Gable, can you state your name for the record?
Yes, my name is Justin Gable.
By whom are you employed and in what capacity?
I'm employed by Xcel Energy as the Director of Resource Planning for the Southwestern Public Service Company territory.
And Mr. Gable, did you submit in this case SPS Exhibits 25 and 26, which include your direct testimony and your supplemental testimony?
Yes, ma'am.
And since those documents have already been admitted into evidence, I have no further questions for Mr. Gable. He's available for cross-examination.
Thank you, Ms. Hardy. Staff, do you have any questions for this witness?
Yes, Mr. Hearing Examiner.
Great. Thank you, Mr. Elliott. I note here that you had reserved, at the beginning 15 minutes, and I'll start the clock there and just let me know if you need more time.
Very good. Thank you.
Thank
Morning, Mr. Gable.
Morning, Mr. Elliott.
It's nice to meet you.
It's nice to meet you as well.
I think we can get through these in 15, but we'll see. There were a number. Were you able to hear any of my discussion with Mr. Hurt yesterday?
I heard some of it. I went back and tried to review as much as I could, but there might be things that I might have missed, but I think I got most of it.
But there were some questions he referred me to you
Yes.
to ask. So I'm just gonna go through those. Can you identify the sources of capacity SPS uses to meet its most recent SPP resource adequacy requirements?
Yes, I believe we've provided that as attachment to my direct testimony. I'll see if I can pull it up. I believe. 1 second. I don't know if that's directly attached to my testimony.
In your direct, I see the attachment production resource model.
Yeah, so we do have attachment JLG1, which is an aggregate of all the resources. I can speak to them. We can also, if I haven't provided that material before, we can definitely provide each individual resource that contributes into the summaries in JLG1 attachment.
I'm not a hearing examiner, but so I can't order a bench request, but I certainly think it would be helpful to the commission. Let me I'll continue on. Does SPS rely on any purchased power capacity or capacity outside of SPS's service territory to meet those resource adequacy requirements?
Thank you for the question, Mr. Elliott. The answer to that is traditionally no. In recent, since the 24 RFP, we have been researching and looking for short-term capacity purchases on the SPP market. We have been successful in identifying some. So yes, going forward, we are expecting to, as needed, rely on some short-term capacity purchases from the market.
Relatedly, can you identify the total accredited capacity within the test period that serves to meet the SPP resource adequacy requirements?
Can you ask the question one more time?
So it's the accredited capacity that is within SPS's service territory that was used for the test period to meet the resource adequacy requirements.
Yes. So on my direct testimony, you can look at both tables JLG4 and JLG5, and the line items that are associated with SPS and PPA, those represent the accredited capacity that's being utilized by SPS to service to satisfy its resource adequacy requirements at Southwest Power Pool.
Okay, so 4.
Yes, table JLG4 on page 23 and
Yep,
JLG5 on page 24.
Okay. So the first column is, this is all accredited capacity. So on page 23, JLG4.
Yes, the line items SPS represent the owned
Okay.
generation accredited capacity, and the line PPA represents PPA contracts that we have for accredited capacity. And the columns represent the year. So in JLG4, we're looking at the summer. So the summer year 2025, some year 2026, and so on. And then in JLG-5, it's the winter position, and those columns are 25, 26. Generally, when we talk about winter, because it crosses over a calendar year, that's December 1st of 2025 to March 31st of 2026. And so for the year 26, 27, it would be December 1st, 2026 to March 31st, 2027.
And well, let me just ask, so yesterday I asked Mr. Hurt about how it aligns the SPP OAT tariff definitions of the winter planning reserve margin and compared to the one that SPS uses. And there was a little bit of a mismatch there. How does that affect these calculations?
So I believe you're asking about, the annual planning reserve margin requirements that are calculated from SPP, Southwest Power Pool. If I have just a few seconds, it might be a little bit of a long-winded answer. So if you have any questions, please feel free to stop me. The way the planning reserve margin requirements are, you have a nameplate PRM requirement for both summer and winter. Currently, a summer PRM requirement is 16% on a nameplate basis, and winter is 36% on a nameplate basis. Now, those values stay relatively stable. In fact, what we're expecting with Southwest Power Pool's new process on setting the planning reserve margin, we should know what those values are 4 years out. That's when the PRM is going to be set for actual compliance purposes. Every year, however, those numbers have to be converted from a nameplate basis to an accredited capacity basis. So when we convert to an accredited capacity basis, that really pins towards thermal accredited capacity. So the 16% planning reserve margin in summer currently is around 7% on an accredited PRM basis. Now, that number will change from year to year based upon individual unit performance across all of SPP. So the values that you see, they will be always reflecting against what we are knowing the nameplate PRM is for the next 4 years. But the individual calculation that is affected by unit performance will change. And we should expect, a 7%, maybe next year it's 8%, maybe the year after that it's 6%, somewhere in that range. But you're not going to see very large swings. But it always does tie back to the nameplate PRM that is set 4 years in advance.
Okay. So thank you. That touches on another question I have, but just to get back to the one I'm trying to ask.
Okay.
And I may not have asked it clearly. So yesterday I was asking Mr. Hurt about how the seasonal resource adequacy requirements that SPS is using align with the SPP. So for instance, the summer period is May through October. That's SPS's summer period, as I understand it. But in the SPP OAT, it's June 1 through September 30th.
I'm not exactly sure where we are getting SPS as a different summer period.
I think it's from it's Mr. Hurt's testimony. And I had all of these open yesterday, so just give me a moment. But I believe it's in Mr. Hurt's testimony, and I think it's at page 3.
I can get that pulled up if you'd like. 1 second. While I'm running this down, what I'll tell you is for resource adequacy compliance purposes, we use Southwest Power Pool's definitions for RA season. So for SPP, that would be June to September, and for winter, that'd be December to March. But I'll look up his testimony to see if we have a potential item we need to correct. So page 3.
I think it was his direct. I have to.
I am not seeing any references to May or October in Mr. Hertz's direct testimony. So I might need some help finding it.
Okay. Well, I'm sensitive to the time, so we'll come back to it. But okay. You know what? It might be in his stipulation testimony.
Okay, let me look there real quick.
Yeah. So he says page 3 of his testimony in support of the stipulation. Lines 11 through 17 is where he's talking about it.
I see that as well. And I think that there might just be a little bit of confusion here. When you say May through October, if you were to consider that May, the end of May, the beginning of October, that would still align with June 1st and September 30th. And for November through April, December 1st through March 30th first. So I do see the confusion here. But just to align, we utilize Southwest Power Pool's resource adequacy seasons for RA purposes.
Okay, so extending it a month on either side here. How does that affect, or what effect does that have?
It would have no effect.
Okay. Because you're just using it internally?
I am not. When I look at the RA seasons, I do not look at May through October. I look at June 1st through September 30th, and December 1st through March 31st.
Okay. So that wouldn't change any of the values that are in Mr. Hertz's table, which is TJH Stip 1. It's page 13.
Is that in the stipulation again?
Stipulation testimony.
Okay. I will say that I haven't. I can't. I don't know that I can speak to Mr. Hertz's testimony on what is changing there. I mean, I can look at that real quick, but I'm a little uncertain. Can you remind me of the page number again, real quick?
It's page 13.
Okay.
And it's a table. It shows the New Mexico SPS 12-month ending November 27 for the production 12 CP allocators. So really, I'm asking, would this discrepancy have any effect on these calculations?
I'm not at that page
Objection.
number.
Yes, thank you. Ms. Hardy, go ahead. What's your objection?
My objection is that the question misstates Mr. Hertz's testimony. I don't think he's said there is a discrepancy.
I'm saying there's an apparent discrepancy.
And that's my objection.
Yes, thank you, Ms. Hardy. Mr. Elliott, would you like to rephrase your question and maybe express that, what you just stated in your response?
It appears that there's a difference between what the SPP tariff says and what's in Mr. Hurt's testimony. And the question is, does using a different seasonal definition affect these calculations?
Mr. Gable, did you hear the question?
Oh, I'm so sorry. I thought that we were waiting.
No, no worries.
Yeah, I thought I was waiting for you, Mr. Hearing Examiner. I'm sorry.
No, I believe, Mr. Elliott, you just restated your question for the witness, Mr. Gable.
Okay.
Can you remind me of the table? Because I still wasn't able to find the table. Is it in the direct testimony or the stipulation?
It's in his testimony in support of the stipulation.
Okay.
I think that if you need the exhibit, would it help if I gave you the exhibit number?
You could also just share your screen if you'd like.
Sure. Yeah. Do you see it?
I do. So I can't speak to the specific table. I didn't produce this. I don't know what goes in the calculations, but what I can tell you for RA purposes at Southwest Power Pool, when we're developing that, we're really looking at the peak during the summer and the peak during the winter. So although it's a range of months, that peak is really identified as the peak in a single point in time. So although the ranges of the seasons, I mean, if there's an apparent mismatch in how the RA season is versus the construction of this table, for RA purposes, there's no impact for considering either expanding that season to a May to October or just identifying as June to September for summer, for instance. I mean, because we are looking at just a specific point in time for the RA purposes. So we might have to talk again to Mr. Hurt, but I'm not seeing any apparent issues, but I didn't produce this table or the calculations behind it, so I can't speak too much to it.
Okay.
Mr. Elliott, let me just pause here for a second. We're at more importantly about 75 minutes into our day three hearing. So you've gone through a little over the 15 minutes, but remember you have extra time, and as I said, I think it's important for staff to have the chance to cross-examine. So why don't we take a break here? Give Mr. Lee a chance and all of us to stretch our legs, get some fresh air, and we'll meet back at 10:42. So we're in recess until 10:42, and Mr. Elliott, you may continue questioning the witness at that point.
Very good. Thank you.
Thank you. Thanks, everybody. We're in recess till 10:40. Okay, everybody, thank you. We're going to go ahead and get back on the record with staff's cross-examination of Mr. Gable. Mr. Elliott, I believe you were about to ask another question. Is that correct?
Yes, sir. So on time, how am I doing there?
Well, you went a little over your 15, so there's about 28 left in the bank. That's the extra bank, let's say. That is cross-exam time that staff allocated to a witness that it didn't use.
Okay. I'm just putting my timer up. Okay. Let's go. I'm ready.
Okay, go ahead.
Okay, so Mr. Gable, I just wanted to follow up on this. So you're aware the stipulation, it uses May through October for the summer period for the Cunningham Bess.
Yes, I saw that in Mr. Hurt's stipulation, and I mean, I'm still not convinced that that's a discrepancy. I mean, I think that those, I mean, it's attached to the month, and it doesn't have an actual date. So I mean, it could just as easily have been June 1st to September 30th. So I'm not sure I see a potential mismatch here.
No, I'm just asking how it changes things. Or if it does. And so let me just make sure I understand. So the winter period is November through April. And so we have like April, May is the oat. Is that what's the SPP's definition for the well, let me just get to this. Let me get back to where we were. Okay. So the difference between the SPP or what's stated here in the stipulation as the planning reserve margins for winter and summer, does that change the ACAP PRM that's listed in TJH Stip 1?
I mean, like I said, I didn't put this table together. I can speak to SPP's rules and the RA construct. But
Okay.
the behind the scenes calculations of the table or what it affects, I can't speak to.
Okay. All right. So let me just move on. I appreciate that. Now my question's for you.
Okay.
So does SPS's financial forecast does it reliably predict the actual system peak loads? Or can it deviate? Or can it deviate like a lot?
We do have different forecasts. You know, we're representing the financial forecast in this for the winter 26-27. It aligns with our expectations. I consider it's a reliable forecast. It is a forecast. So I didn't construct the forecast. I can't speak to its underlying mechanisms for development. We utilize the planning forecast. We've utilized the planning forecast in both RFP evaluations. We've discussed it in IRPs. We also look at that in our RPS filings. The financial forecast is utilized here, but I cannot speak to how those individual forecasts are developed or anything specific about the mechanisms of their development.
Do you recall the SPS or SPS's actual summer 2025 generation peak?
I don't have that information in front of me right now.
Okay. Would it surprise you if the actual peak was 206 megawatts over what was in SPS's forecast?
Like I said, I don't have that information in front of me, and I don't know what the actual delta was. Variability in forecast though can depend on lots of different issues. Like I said, I don't develop the forecast, and I don't know what the specific assumptions around any inputs that might be related to differences in actuals versus forecasted. So I can't speak to that.
Well, let me put it in a different way. It is a 206 megawatt discrepancy material. Would it be if you were looking at a forecast?
I can speak to my use of the forecast. My use of the forecast are to project out future resource adequacy. Most important to me is making sure that we have enough resources to be able to serve our load forecast that we project in the future. Load forecasts do have variability. I think that in general, I can't speak to the accuracy versus of actuals versus projected. I know that there's a number of things that can go into what affects actual. I mean, load growth that actually occurs. I can't really speak to. I'm sorry, I can't speak to that.
Okay. But in terms of being a resource adequacy expert, that degree or that difference, and I'm not saying it's up or down, like 206. I'm just saying, like, would 206 megawatts be a meaningful error, or I know it's a forecast, so I don't even know if we call it an error necessarily, but difference from what is expected in your mind, planning for resources?
I can speak to the inverse of being short, and being short 200 megawatts would be a significant deficiency payment.
Okay. So when you're dealing with these forecasts, I'm just curious, what level of uncertainty are you comfortable with? Or does SPS tolerate in terms of these forecasts?
I'm sorry, I didn't develop the forecast, and I don't know the mechanisms that go into developing the specific forecast. I know that's something that I utilize the forecast. I understand what's in the forecast, but on exactly like what the mechanisms are and what are the tolerances for the specific ability to develop that forecast, I can't speak to.
But I mean, you use them. You're an end user of the forecast.
Correct. I'm an end user.
So if you're off by that much, is that subject to further inquiry and investigation by SPS?
Objection.
As to how to improve a forecast?
Objection.
Okay, let's unwind it a little bit here. Ms. Hardy, what's the basis for your objection?
Mr. Gable has already testified he doesn't prepare the forecast and he doesn't know how SPS evaluates the forecast. He's said that he uses it as an end user. So I think it's asked and answered to the extent possible, and then outside of his scope.
So the question, precise question you're objecting to, Ms. Hardy, was Mr. Elliott's question that was, so if you're off by that much, is that subject to further inquiry and investigation by SPS? Is that correct?
Correct. And I also think it's assuming facts, not in evidence, with respect to being off by that much. I don't know that there's any evidence in the record that's been referenced about being off by an amount.
Sure. Thank you. Mr. Elliott, your response?
The 206 is a hypothetical. The question is, as an end user of forecasts, what the tolerance level for a discrepancy is, and what SPS does subsequent to finding a discrepancy or, an undershot or overshot of a forecast.
Sure. I think, Mr. Elliott, you can avoid the objection by phrasing your question in that fashion to Mr. Gable as an end user. But I think that Ms. Hardy's broader point stands. So if you would like to ask Mr. Gable about his awareness or knowledge as an end user, to the extent of his knowledge, I think that would be permissible.
Mr. Gable, did you hear how the hearing examiner phrased that?
I did.
Do you want to just take a stab at answering it?
As an end user, my thoughts are always forward looking on forecasts and making sure that when I'm solutioning out RFPs or serving resource adequacy, that I have sufficient capacity to meet the load that's projected. Because ultimately, right now, with Southwest Power Pool, I pay a deficiency payment based upon what I am projecting and making sure that I have enough capacity resources to solve that. Now, any mechanisms for review process and things like that, those may be in place. I am not here to testify on those processes behind the load forecast. It's not something I had in testimony or prepared to discuss today.
Okay. Let me move on to your direct. You note a 77 megawatt capacity shortfall in your direct. Is that still SPS's best estimate for the 26-27 deficiency, or has it changed?
Yes, let me get that pulled up. So in the near term, we have secured a short-term capacity purchase for that period. I think that there's other things that are still moving. We haven't started the workbook submittal for that. That number could
I'm sorry, we haven't started
the workbook submittal. That starts in August. So it's something that we'll be looking at soon. We try to get these numbers up to date. Plant outages can affect that. Resource unavailability, updated load forecasts, those can change. We've done our best effort to procure short-term capacity in this period. So yes, those numbers have been updated.
So the number has changed. Okay. Has SPS updated its financial load forecast since it identified this deficiency?
I do not know that we've updated the financial forecast since this testimony filing.
Okay. Can I just direct your attention to Miss Hashaloom's testimony?
Okay.
Which of course I had open. Yeah. So it's Ms. Hashaloom's direct testimony. When you can open that.
I'm looking. If you have it,
sure.
For the sake of time, it would be probably better to share it on screen.
Okay. So do you see this? When I start sharing, I lose some of my screen.
I see it. I see. I'm assuming you're referring to the highlighted portion.
Yeah. D. This is SPS's response to staff's third set,
Yes.
37 3-75.
Yes, I see. Indicates that we have not updated the financial forecast.
Okay. What specific factors account for that reduction from the 77 megawatt to 45 megawatt?
I don't know that I followed your question. Was it 45 megawatts? What are we talking
Well,
about?
I'm sorry. So let me the deficiency has changed. Is that correct based on these new resources you've identified?
New resources I've identified.
Yeah, you just referenced new short-term capacity.
Oh, yes. I don't have the numbers pulled up in front of me right now, but yes, the numbers would have changed. But I would also say that we haven't prepared the workbook yet. There can be changes for, before that workbook submittal and all the way up until November.
Okay. So I'm looking at the same response. I'm looking at this same set of questions. And the question for E is whether SPS currently projects the same 77 megawatt deficiency. And you see here, this is the response. So it says SPS is currently projecting a 45 megawatt deficiency. With this additional support of an expected 176 megawatts of interruptible program participation.
Yes.
Is that the resource that you're talking about?
No, it's not. And this number could also change. So as we go to finalize that workbook submittal, this is what we were projecting, and we'll ultimately have to review and see what actually is signed up on interruptibles.
So it may be more than what's even reflected here.
It's most certainly less.
But the deficiency.
No, the amount of interruptibles that we are expecting.
Okay. And but that information hasn't been updated or provided?
No, not at this time.
Okay.
But like I said, we haven't finalized the workbook, so many of these numbers will change as we are going to finalize the workbook.
So I guess that answers my next question, which is the 45 megawatt figure itself final?
No.
Okay. So you expect it to change?
Yes.
Okay. Have you completed, and I can stop sharing. Have you completed the 2026 V1 financial load?
Or did you finish your question, Mr. Elliott?
Oh, I thought somebody started talking. Sorry. But yeah, the question is in full. Have you completed that 2026 V1 financial load forecast or finalized the thermal resource accreditation values?
So this discovery response was definitely at a point in time because I do know that the 26 V1 financial forecast has been completed. So the discovery response seems to be a little bit dated. Has the performance-based accreditation values been finalized? Yes, but resource availability has not necessarily.
That's something I assume you're tracking as the resource adequacy and looking at the forecasts, whether the numbers have been locked in.
Yes, I would say that the numbers, I mean, we initially submit a workbook. We start that in August. And then if anything changes, if we have an outage of a resource that we are projecting to be through the entire season, then that would be a reduction to our resources or our credit capacity. So although the credit capacity percentages have been locked down, the resource availability is not necessarily locked down.
Okay. Well, given the load forecast that's in this case hasn't been updated in over a year, and we have these changes, the 176 referenced in the discovery response, and the pending thermal accreditation and financial load forecast. What do you think updating this data would have a benefit to New Mexico customers relative to the, I guess I can say, stale 77 megawatt deficiency that's embedded in the case?
I would say that this is an actively moving thing that we are always tracking. Is, you know, when we're planning, you know, for an actual workbook submittal, we're doing our best to make sure that those numbers are up to date all the way up until the final lockdown of that workbook, which is in November. So, you know, it could be updated at any point in time, but until the line is snapped, you know, in November, I think that there could be potential changes. Now, for this case and what we're discussing, I think that, you know, these values are sufficient in being able to understand the concept and, you know, the issues at hand. I don't think that that really changes. And, you know, individual numbers can change, but the process doesn't.
Okay. Are you familiar with, well, let me ask you this. Are you aware of the rate-making principles the commission adopted in 250066?
That's not my area of expertise.
In that case, the commission said SPS shall not rely on projected or speculative load growth alone to support jurisdictional allocation costs in a future base rate case. Was that ever brought to your attention?
Objection.
Yes, Ms. Hardy?
Mr. Gable has stated that does not have expertise regarding rate making issues or the issues on rate making from that proceeding.
Mr. Elliott?
I asked Mr. Gable if it was ever brought to his attention what was in that final order.
Okay, I think I'm going to overrule the objection and allow that yes or no answer. Mr. Gable, was that ever brought to your attention?
I mean, if I'm limited to yes or no, I would say I don't know. I don't know if the principles that are identified in that were made to my attention or not. I don't have that information to know what specifically came from that or what was provided to me. You know, information is provided to me for lots of different parameters. I don't necessarily have a one-for-one relationship of where that specific component came from. So I don't know that I can answer that question truthfully.
Thank you, Mr. Gable. Go ahead, Mr. Elliott.
I have no further questions. Thank you, Mr. Gable.
Thank you, Mr. Elliott.
Thank you, Mr. Elliott. And Mr. Elliott, just for your situational awareness, there's 3 minutes remaining in that extra bank of cross-examination time.
Great, thank you.
Okay, thank you. Okay, so Ms. Hardy, do you have any redirect for your witness?
I do not. Thank you.
Thank you, Ms. Hardy. So I will then ask and defer to my co-hearing examiner, Mr. Gecko, to see if he has any questions for Mr. Gable.
I do have a few questions. A couple were passed from yesterday, if I remember correctly. I have some notes about that. Good morning, Mr. Gable.
Good morning, hearing examiner Gitko. It's nice to see you again.
Good to see you as well. After yesterday, I went back and realized there was a hole in my knowledge of, because they're being discussed a lot. They were just discussed a lot right now about load forecasts. And so I went back to the list of witnesses that is provided with the application and what each testified to. And I didn't immediately locate the load forecast witness. And I didn't hear it talked about just now. Who's providing you the information that you're working with as an end user?
Hearing examiner Gitko, are you asking me what persons inside the company are responsible for providing that to me?
Yes, as one, and then the second part would be who that testified in this case is included in that list.
Let me see if I can. So the person that is directly responsible for load forecasting would be Dr. John Goodenough. That's reported through his department. I don't know that he's necessarily the one that specifically creates every load forecast. I mean, he's a team of folks. I'm not certain that he is a witness on this case. Actually, he is. Dr. John Goodenough is a witness in this case.
Okay, yeah, I know that as well, and I had passed on it. Okay, thank you for that. For the purposes of this case, is that who you interacted with to get your load forecast, or it was a member of his team?
It was almost certainly a member of his team. Would you like their names as well?
Sure, please.
The individual I most often work with is Mr. Travis Whalen.
Can you spell the last name?
Yes. Whalen.
Thank you.
Okay, I was just reviewing testimonies. So almost definitely, did you work with Mr. Whalen to get on to understand the load forecast to support the testimony that you filed in this case?
Yes, I don't remember any like specific, but generally I would expect that's who I've worked with.
Okay, thank you. Let me go to the other. How often do you receive updated load forecasts for SPS's New Mexico service territory?
I don't think that there's like a firm schedule. I think in general they aim for 2 forecasts a year.
2 forecasts a year?
Mhm.
Okay. And is one of those for winter and one of those for summer and associated with the peaks, or?
No, the forecasts that we receive are generally because associated with our modeling, we require a full 8,760 hour forecast for, you know, however far into the future they provide that, but that forecast is just an update of the exact same data. So it's not a seasonal forecast.
Okay. Sorry, I have notes on a number of sheets of paper. Okay. Sorry, I got confused a second between Mr. Whalen and Mr. Wayner. I have a question here that was passed to you from Mr. Wayner.
Okay.
And so this goes back to the when you developed the 2024 RFP that led to the selection of the 6 battery energy storage systems that were considered in case 2500085 dash UT. Did you work with your Treasury Department to mitigate the impacts of imputed debt on the resources that would come from contracting for the resources that were allowed to be selected through that RFP?
Thank you for your question, Hearing Examiner Gitko. The answer to the question for the 24 RFP is no. Imputed debt was not considered in the evaluation.
Was it a prior RFP that you considered? So the 2024 RFP was used to select those 6 batteries that were selected for 2500085, correct? Am I remembering incorrectly?
Well, I think that maybe some of the confusion might be related around the 25 RFP that we are currently waiting our independent monitors final report on. I think that previously you and I had a conversation about any changes that we did between the 24 RFP and the 25 RFP. And one of those was allowing for bids to include a variable energy payment instead of, or what's the right word? That was a change that we had implemented previously. We were only allowing an energy and a capacity payment, and we changed the 25 RFP to allow a variable energy payment to incorporate both into a single payment.
That's correct. And so the 2024 RFP, thank you for that history again. Thank you. The 2024 RFP is what was used to select those 6 battery energy storage systems that were selected and were up for approval in case 2500085, correct?
Yes, the 24 RFP produced those batteries.
And the RFP limited battery resources in the RFP to a period of time of usage of no longer than 15 years, is what I remember. Is that correct?
That is correct. And that was a measure to be able to, I think I need to expand on my answer. That was a provision that was to help mitigate the risk of imputed debt. That was more of a upfront, requirement. It was not something that was incorporated into the evaluation of what the imputed debt risk is.
And you didn't have to do that further evaluation because the RFP was limited to resources that would eliminate unwanted risk of imputed debt that would have been caused by battery contracts that exceeded 15 years, is how I understand what you just said. Is that a fair understanding?
Yes, I would say that I'm not from Treasury. The idea that, of my understanding, is that it was to help mitigate the issues of imputed debt by limiting to 15 years. I don't think that it eliminated the issue.
Fair, good clarification. So just to go back to, the initial question was, I think I asked whether, you worked with Treasury. Maybe that worked was the wrong word, but were you given instructions by Treasury or guidance by Treasury to not allow for terms over 15 years due to the level of imputed debt that would result from contracts over 15 years?
I would say that it's been a little bit, and I wouldn't be able to name the specific person that I worked with or where I got that exact requirement from. But in general, that's the direction I would have assumed it came from. But it's been a little bit.
All right. Thank you. That clears up the questions from yesterday. Thank you. Okay, on the next topic, and we've talked about this, and you kindly filed some, and I apologize, I wasn't able to review it in the last 24 hours. You responded to a bench request in that case, and some of that was with respect to arbitrage value and ancillary services, if I remember correctly.
I do remember that.
So I had a conversation with Mr. Trowbridge yesterday, and he's filed testimony in this case with respect to providing the arbitrage and ancillary services benefits to New Mexico for the Cunningham BES that is stipulated to be 100% dedicated to New Mexico. Are you familiar with that conversation from yesterday?
Yes.
Okay. And my curiosity, I felt, I understood the arbitrage value due to the node pricing through the SPP and the ability for SPS to calculate those values. What I didn't come away understanding was how it's going to function for SPS to calculate the 100% value of ancillary services provided by the Cunningham BES that is going to be 100% dedicated to New Mexico. Could you provide an additional explanation for how that will be calculated and where it will show up on filings so that it can be tracked moving forward?
I can give some discussion on that. We'll see where the conversation goes. I'm not confident I'll be able to provide it entirely. But what I would say is when we identified energy arbitrage value in the RFP, what we're doing is really providing directional indication that that's what we expect, and our modeling is also showing that. Now, the actual dispatch of these resources and any kind of market value that they're providing are ultimately going to be based upon economic dispatch in the market. And so projecting those values, I don't know that that the values can't be calculated in the future about what was produced. Now, projecting those values, I think that might prove to be difficult. But I think that those values will absolutely be able to be calculated after they occur.
And so your answer, you started with a reference to arbitrage value. And my curiosity is with the value of ancillary services. It's something I don't understand how that's calculated. I thought maybe there's some kind of system set up in SPP. I just don't know. And I understand the value of ancillary services in a non-monetary description to be the ability to ramp up and down quickly, the ability to minimize the amount of spinning or mitigate the amount of spinning reserves that you need on the system, you know, load balancing effects, et cetera, et cetera, et cetera, localized, you know, distribution structures to, you know, mitigate trouble with transmission. How are those values going to be calculated and turned into a dollar benefit for New Mexico?
Mhm. So those values are captured, you know, in the marketplace. I don't do the actual dispatch of these resources or bid them into the market. I will say that those values are captured. I can't speak to, you know, how we calculate those and provide them as a projection.
Sorry, just not as a projection. I'm not looking at how you estimated through the RFP process. And maybe, you know, maybe I'm asking the wrong person then, but I would think if there was a standard for how that is calculated, then projections and estimations would be based upon the processes for actual calculation of that value. So I'm curious to know if there is a solid structure, if there is a system in place, if there is a system defined for providing a monetary value for the ancillary benefits that are provided by battery energy storage systems.
Mhm.
And yes or no, is there or not?
To my understanding that there is a way to identify those and capture those specific values, but I do not submit these resources into the marketplace, and I'm not familiar with the software that's utilized to do that. We can definitely get some more information for you, but those particular services are captured.
Okay. Then I think it's important in that there's testimony that says that those benefits, the value of those benefits will be provided to New Mexico for that resource. SPS Council, I'd like to make that an additional bench request to have SPS provide the methodology and detail for how the monetary value of the ancillary services benefits will be recorded and provided to New Mexico. I think it closes the loop on that topic.
We're happy to put that together, Mr. Examiner.
Okay, thank you. And then I'm just checking my notes. Thank you for that back and forth, Mr. Gable. And then the only last thing I'm going to do is, I didn't follow everything in the discussions that have happened thus far, but I had a moment where I didn't understand whether the questions had been asked to both Mr. Hurt and yourself, and whether you were able to answer the questions that were passed to you. And so I'm just going to reread what those questions were yesterday. And because I got a little bit lost in that conversation. And one of them was, do you have a finalized accredited capacity value for Cunningham BESS, or are you still relying on an estimate? Does that question make sense from me pulling it from yesterday?
It does make sense, hearing Examiner Gecko. I think that the answer to the question is for the winter 26-27. Yes, we have an accredited capacity value that's been assigned for that resource. However, for us to continue to project future RA positions and develop either future RFPs or understand our capacity position, future values past winter 26-27 are an estimate.
Okay, thank you. And then that's clear. That's clear. That's clear. Okay, that's the only one that I felt like I lost track when I was trying to follow y'all's conversation. Okay. Those are all the questions that I have right now. Thank you.
Thank you, Hearing Examiner Gecko. It's nice talking to you as well.
Thank you, Hearing Examiner Gecko. Ms. Hardy, do you have any follow-up questions for this witness?
I do not. Thank you.
Thank you so much. Okay, I believe we have a little bit of organizational matters to just discuss and keep an eye on here, specifically with respect to witness availability. We're coming up to the lunch hour. I believe that the next party in order of presentation of witnesses is the New Mexico Department of Justice. Is that correct, Mr. Hayden?
Yes, Mr. Hearing Officer, we are prepared to present witnesses as requested.
Excellent. I think it just is going to why don't we take a 5-minute recess and I'll just confer with Hearing Examiner Gecko how we want to manage the next half hour and our return from lunch. So we're in recess till 11:33. Thank you. Hi, everybody, and we're going to be in recess for just a few more minutes. So just hang tight, and we'll be back momentarily. Thank you. Thank you, Mr. Hayden. Okay, everybody, thank you for your patience. We are back from our recess and on the record. I will recognize New Mexico Department of Justice. Mr. Hayden, are you prepared to enter the testimony of your witnesses into the record?
We are, Mr. Hearing Examiner.
Okay, please proceed.
Good afternoon, or good morning, Mr. Gigax. How are you?
Oh, okay.
May I swear the- Go ahead,
Wait a
Judge.
second. Before we swear the witness, let's just go ahead and get the testimonies admitted here. It was all stipulated to, I believe, Mr. Hayden. So let's just offer it, and then we'll see if there's any objection and get it entered into the record, as we did with the other parties.
The New Mexico Department of Justice would like to enter in the testimony of Mr. Doug Gigax and also Matt Bandix.
Thank you, Mr. Hayden. Are there any objections from the parties to enter these testimonies into the evidentiary record? Thank you. They are admitted. Thank you, Mr. Hayden. Now, Mr. Gigax, we'll swear you in here momentarily. The court reporter will make some arrangements and then signal to you when he's ready.
Dr. Gigax, would you please raise your right hand? You solemnly swear the testimony you're about to give, the matter not pending, should be the truth, the whole truth, nothing but the truth.
Mr. Gigax, I don't think I can hear you. No. Nope.
Can you
Not
hear me?
you. Yes.
Okay, for some reason my headset mic isn't working.
No problem. We all manage these technical issues. Go ahead, Mr. Gigax. Mr. Lee.
Would you solemnly swear the testimony you're about to give, the matter not pending, should be the truth, the whole truth, nothing but the truth?
I do.
Thank you. Go ahead.
Mr. Gigax, can you please state your name and business address for the record?
My name is Doug Gigax. My business address is 4805 Sage Road, Las Cruces, New Mexico, 88011.
Mr. Gigax, who is your employer?
I am retired from New Mexico State University. I am engaged in consulting with the New Mexico Department of Justice through a separate contract.
Mr. Gigax, on behalf of whom are you testifying in this proceeding?
The New Mexico Department of Justice.
And are you the same Doug Gigax who prepared direct testimony filed on behalf of the New Mexico Department of Justice in this matter?
Yes, I am.
And do you have a copy of the testimony in front of you?
Yes, I do.
Are there any attachments to that testimony as well?
No, everything was embedded in the testimony on my tables.
Thank you. Are there any changes or corrections to your testimony?
I did find one. It's kind of minor. On page 12, line 9, table DG2 should actually be table DG3. And then the next sentence, table DG2 shows the table should also be DG3.
Thank you for that.
And that's it.
If you were asked the same questions regarding this exhibit today as when you originally filed your testimony, would your answers be the same?
Yes, they would.
Mr. Hearing Officer, I tender Mr. Doug Gigax for questioning.
Okay, thank you, Mr. Hayden. Before we do that, would you like to take the opportunity to ask the fairness question that the chairman posed to your witness?
If someone could repeat that question, I'm sorry.
I'm sorry, I can't repeat it. I mean, well, okay, so maybe I'll just do it for let me find it for you, Mr. Hayden. But we really need to okay, so
Judge, off the record, I think it had to do with fairness between New Mexico and Texas.
yes, I have it here, Mr. Lee. Thank you. So the question, Mr. Hayden, is from a customer point of view, how the signatories, and in this case DOJ, witness views fairness in a world where customers are going to be paying different rates in New Mexico for the same thing that they're paying for in Texas. That's the question.
Well, Mr. Gigax, I think you heard the question, but can you address the issue of the residents of one state of New Mexico and the other state of Texas? Is there a fairness issue here if they're paying different rates?
Excuse me. Yeah, yes, all I know about the Texas rates is what the witness Trowbridge said yesterday. And he noted that the current New Mexico rates are lower than the Texas rates. So that would be, of course, to the advantage to the New Mexico customers. I think that the commissioner also asked, as I remember, the fairness question also involving, is it fair that New Mexico pays for something that Texas does not? And I think in that sense, I would respond saying, I don't think it's a matter of paying or not paying as much as when the customers pay. In New Mexico, there's the future test year, which allows the company to include facilities that come into service up to a year after the new rates are put into effect. So there's less regulatory lag. So it's kind of like in the New Mexico test year case, let's pay now. All right. For Texas, there's more regulatory lag, so that it's kind of a pay me later situation, wherein the Texas customers will pay at a later time because of the regulatory lag. But in the end, I believe that all customers will end up paying what has been fairly allocated to them.
Thank you. Is there any other follow-up, Mr. Hearing Officer?
No, not for me. This is direct at this point. So if you have no more questions on direct, I would then ask Mr. Elliott or Ms. Amer for staff. They had allocated originally 10 minutes of cross-exam time for the witness, Mr. Gigax, and I asked them if they are going to use that time here.
Mr. Hearing Examiner, I do have one question for Dr. Gigax.
Sure, please proceed.
Dr. Gigax, it's good to see you.
Hey, good to see you too, Mr. Elliott.
To follow up on the hearing examiner's question, or the commissioner's question, that was a useful distinction you were drawing when people pay. But in the moment that they're paying and they see a difference in New Mexico customers paying more, what about then?
Okay, good question. I think that in my experience, most residential customers are concerned about their bill. So they're looking at the total bill effects. And I would say that the question of when a particular state ends up paying for the cost of a facility is relevant there as well, because if you have the situation where New Mexico customers are paying for it earlier than Texas customers, then all else equal, in future rate case, the New Mexico increases will be lower than what they would be if that facility had to also be added into the case. So there's an effect across time as well, so that pay me now means I'm going to pay a little bit less later. Pay me later means I'm going to pay a little less now. And one case, of course, does affect the next rate case.
Thank you.
Hope that answers your question.
I think it helps the commission. Thank you.
Thank you, Mr. Elliott. Is that all your cross-examination?
Yes, Mr. Hearing Examiner.
Thank you. Mr. Hayden, any redirect for your witness?
No, Mr. Hearing Examiner, no redirect.
Thank you, Mr. Hayden. So at this point, I believe Hearing Examiner Getko has some questions for Mr. Gigax. I'm not sure exactly how long that's going to take, but I'm just going to pause before we do that. We're running up to our lunchtime. So any questions that Hearing Examiner Getko would like to ask, we'll continue after our lunch break. And right before noon, we'll take another brief pause for our outlook and situational awareness as we go into the second half of our hearing today. So with that being said, Hearing Examiner Getko, I believe you have some questions for Dr. Gigax.
Good morning, Dr. Gigax.
Good morning, Hearing Examiner Getko. It's good to see you.
Good to see you as well. I'm going to start in your direct testimony on page 30 and going over, starting at line 20 there, and then going over to page 31 on line 9, you have a discussion of the EAP program.
So I'm there.
And as part of that, you identify that the residential service class is allocated about 54% of the total proposed initial annual budget of $750,000. Correct?
That's correct.
And then there's let me make, you go on and you state at page 31, lines 15 to 17, supporting programs that offer assistance to low-income households is a high priority of the NMDOJ. While ideally, I personally prefer taxpayer-funded programs for the provision of low-income assistance in general, I think that SPS's proposed EAP is a good second best proposal. Can you explain your preference for taxpayer-funded programs, please?
Yes, I will. In my perception, the social safety net programs yield a benefit to all of society. All right, that's my premise. Even to members of society that are not receiving directly the benefit. So because of the benefits are received benefit all of society, I think that all of society should share the burden of funding the cost for those programs. Also, I prefer taxpayer funded because then they become programs coming from the legislature, and individuals then therefore can respond to legislative votes by how they vote in the next election. So for those two reasons, I prefer social safety net programs to be funded by the taxpayers' funds. I realize, however, that that is not done in the case of all social needs and social safety net programs. So other mechanisms are typically utilized. And in that sense, I think as a non-taxpayer funded program, SPS's proposal, although I believe the $750,000 to be kind of modest, is a good first step.
Okay,
And-
thank you. And that 54% sticks out to me when I think about the percentage of revenue requirement that is allocated to the residential class. And given your statement of how all of society benefits and it would be nice to have all of society pay, how do you square 54% of the cost of that program, not of the tire program because there's shareholder contribution of 750,000, but how do you square that with the general positions that you have as a foundation for your understanding of these societal programs?
Yes, good question. I think that the fact that SPS does not put the burden solely on the residential class to pay for this support, that other customer classes are also contributing, is kind of in line of my idea that everyone benefits and therefore everyone should pay. We can quibble about what those percentages should be. I think the mix between the part of it being weighted by the class's revenue requirement share in the cost of service study and part of it by customer counts tries to strike a balance between those two factors, that residential class gets the benefit, but all people should be contributing. The mix of those weights, I think we could quibble over. Of course, being a representative for the residential class, I would like the customer counts to be lower because that would be to the advantage of the residential customers. But I think that any type of weighting scheme is somewhat subjective. And but I do, in fact, applaud SPS's first stab at this to a very, very important issue of affordability.
Thank you, Dr. Gigax. Thank you. That helps me understand better. I'm going to turn to another position in I say position, I got to be careful, another location in your testimony. Just one second here. Okay, at the bottom of page 8 of your direct testimony, lines 18 to 19.
Yes, I see. I'm there.
And it's short. You state that the large increases in New Mexico forecasted load in the future test year as compared to Texas are certainly striking. Could you extrapolate on what you mean by striking, and is that relative to what you are historically accustomed to seeing? Is that relative to, oh, it's striking the difference between the two states? Is it a mixture of all the above? Could you speak a little bit more about that?
Sure. Yeah. By striking, I just mean that it caught my eye because of the relatively large increases. Then I got thinking, well, what could be driving that? And being a citizen of New Mexico, I'm aware of what's going on in my own state. And I know there's been a lot of growth in the oil and natural gas industries in southeastern New Mexico. I just didn't realize it had that big of an impact. So I'm not saying that the forecasts or the percentages are wrong. I'm just saying that I knew there was growth in that area, but I didn't realize it was that much. So it's caught my eye.
Okay, got it. Thank you for that. I don't have a follow-up on that, and it's 11:58. And here in Examiner Schaefer, you had said we'd pause just before noon, so I'm trying to be proactive with that.
Yeah, thank you. I think that's good. So, hearing examiner Gecko, I believe will continue his questions for Dr. Gigax once we return from the lunch break. I wanted just to share some thoughts with the parties before we proceed. And I think Ms. Lynch is anticipating one of the items that I wanted to discuss. So Mr. Eubanks is not available for the rest of the week. So hearing examiner Gecko and I were discussing the possibility of having him appear right after we're finished with New Mexico Department of Justice, unless there's any objection from the parties. And then at that point, if that's acceptable to the parties, we will proceed with what was arranged yesterday and this morning with large customer group appearing and then OPL subsequently. So it looks like Ms. Lynch, you still have your hand up. Would you like to share your thoughts?
No, sir. That schedule works for us, and I think that we may have some flexibility if needed, but again, what you just stated works for us.
Okay, thank you, Ms. Lynch. Mr. Rushoff?
Yes, is Mr. Eubanks available for the remainder of the day? And I ask because our witness, Miss Hashlamone, was unavailable after 2 o'clock, so we were hoping to get her up shortly after lunch and then hopefully off the stand.
I see. Okay, this is helpful to consider. So, large customer group will have 3 witnesses, correct?
That's correct.
Okay. Yes. So why don't we
May I interject briefly?
yes, of course.
Leadership?
What are your thoughts? Here,
I
Examiner
was
Gecko?
trying to get to the Excel spreadsheet that you're more accessible to. In addition to my possible reservation, is there reservation of time from other parties for Miss Ashlemoon?
Yes, there's 7 minutes for staff.
Mr. Hearing Examiners, we are waiving that 7 minutes of cross-examination of that witness.
Okay, great.
At this time, I do
Go
not
ahead.
have questions for Miss Ashlemoon either. I was able to clarify that. So that may resolve other than the possible direct examination. To speak openly here.
Yes, I don't have any questions for Ms. Hashlemoon either, Mr. Rushoff. So if there is a witness on direct that you could ask that question to, that the chairman has signaled is important for his consideration, then I believe we may be able to waive her appearance.
Yes, I would offer that we would direct that question to Mr. Bieber to offer on behalf of the New Mexico Large Customer Group. So
Okay.
I think if we are willing to waive Miss Hashlemoon, that'd be helpful.
Okay, yes, then why don't we go ahead and do that, and then we will just proceed again with Mr. Eubanks immediately and after lunch, and then we'll flow through to large customer group. Well, immediately after lunch is continuation of hearing examiner Gecko's question of Dr. Gigax, and then anything for Mr. Bandic, and then moving to Mr. Eubanks for CCAE, and then large customer group. Okay, Miss Miller, yes, your hand is raised.
Yes, thank you. I just wanted to quickly remind the hearing examiners that FEA and LES witness James Lako, if he's going to be called, he's available any day, but it has to be after 11 a.m. So I just wanted to remind.
Yes. Yes, very, very well taken. I have that here on our matrix. So thank you for that, Miss Miller. Okay, so Miss Lynch, do you still need to express something?
Yes, Alex Eubanks is available at any time. He has no restrictions going forward, if that helps at all as you're figuring things out. And then he also is wondering, do the hearing examiners or any parties have questions at this point in time for him?
I think we may, Miss Lynch. So I don't want to, totally dismiss that witness out of hand yet. But when you say available going forward, you mean he's available tomorrow and Friday as well, or?
Yes.
Oh, okay. So
Yes.
there's
So if
no.
we can contribute to the flexibility needed, we can.
Okay, excellent. So then we can just go in order then of appearances and have CCAE present its testimony and witness after OPL. Is that correct, Ms. Lynch?
Correct. Yes.
Okay, excellent. All right, so it's good. It's always good to do air traffic control. So let's reiterate what's going to happen here once we get back from lunch. We will continue with hearing examiner Gecko's question for Mr. Gigax, and then anything for Mr. Bandic. And then we will move to large customer group, and then we will move to OPL. And then if we get to it today, which seems likely, CCAE with Mr. Eubanks. Is that what everybody understands? Excellent. Okay, so now for the good part, let's take a recess until 2:30 when the World Cup match has concluded. Just kidding, just kidding. I wish we knew when we scheduled this hearing. Well, unfortunately, we can't do that today. But we'll be back here at 1:20. That'll give us an hour and 15 minutes for lunch. I think it's well deserved. So everybody, take a break, and we'll see you back on the record at 1:20 p.m. Thank you, everybody.
And everybody, please turn off your cameras and your microphones.
Good afternoon, everybody. I know it's just a couple minutes before we were set to reconvene, but I have some technical news to share with everybody. The Santa Fe Office of the Public Regulation Commission is without power at the moment. So Mr. Hearing Examiner Getco is not able to resume the questioning right at this moment. So he's working to figure out what the problem is. And I'm on standby. He's on standby too. So once we get that sorted out, we'll let everybody know. And in the meantime, I think the parties can just sit tight, take care of whatever business they need to in the meantime. And apologies to the witness and to the parties for this occurrence. It's certainly out of our hands. But like I said, just everyone sit tight, and we'll be back in touch shortly once we have an update. Thanks, everybody. Okay, everybody. Is everyone there? So thanks for bearing with us. It looks like there is the entire city of Santa Fe is almost without power at this point. More than just the entire downtown area, Agua Fria area, the north of the city, east of the city. So I think that even some of the council here in our proceedings today are unable to even have access to this Zoom meeting at the moment. So we'll send out an email here in a few minutes to all the parties to alert them to this outage. I think tentatively what we might try to do is hope, pray that this gets resolved maybe in the next hour and a half or so. I'm going to say tentatively for the moment that we might recess until 3 p.m. And in that time, just give PNM an opportunity to fix the situation. Hearing Examiner Gecko is calling me right now, so just give me a couple minutes and I'll be right back with some final information. Thank you. Okay, everybody, thanks for your patience. What we decided to do is recess until 3, just to see if this is something like a spilled drink on a distribution line or something like that. Miss Amer is joining by phone here, so it'll be good to have her so we can get as much communication as possible. Part of the other issue here is that with some of our colleagues and other participants not having access to power in Santa Fe, the communication is going to be a little bit difficult. So I'm going to communicate with all of you here, and then we'll also send out an email to all the parties right after I finish describing what our next steps are. So as I was saying, we'll pray, see if things are restored by 3, and then if not, then we'll recess till 9 a.m. tomorrow. I want to recess till 3 just in case there's an opportunity for this to be resolved, and just to continue with the momentum and getting our witnesses heard and all that the proceeding requires as much as possible. So we'll try that, and please also communicate with your colleagues and parties that may have been kicked off the Zoom by phone or by email. We'll do it by email as well, and let them know that we'll reconvene at 3. Also, just on a procedural matter, I did discuss with Mr. Hearing Examiner Gecko, and neither he nor I have any questions for witness LeConte, Mr. McMillan. So I think that may resolve an availability issue going forward. One of the things that I did with Hearing Examiner Gecko once we became aware of this outage was to just check again availability and see what consequences that would have if we moved to had to recess until 9 a.m. tomorrow. So any questions or thoughts before we take our recess until 3? Okay, so before we totally recess, Mr. Marcus, I believe you may have communicated with Mr. Hayden, but like I said, we'll communicate this via email, but you might also feel free to reach out to him by phone as well. And Miss Amer, are you on the line? Okay, maybe she hung up. Okay,
Yes,
so
I am.
okay, great.
I'm on the line,
Great, Miss Amer. Great to see you.
and
Did you hear what I just?
I don't have power. I don't
Yes,
have power, but I'm on my phone.
yes, excellent. Did you hear what I just communicated?
And I communicated it to all of staff.
Great, excellent. Okay,
And
okay, thank
we have
you.
no questions from Ms. LeConte.
Excellent, thank you,
Or
everybody.
Mr.
Okay, so
Okay.
let's pray, think good thoughts, and we'll reconvene here at 3. I'll keep the YouTube on, I'll keep the Zoom on, and everything, just as if we had a really long lunch break, and we'll see each other again at 3. And
Right, bye.
Bye.
Any luck, Judge?
I believe so, Mr. Lee. I think our positive thinking and maybe some diligent efforts on behalf of the utility resolve the situation. So we'll check in with everybody and make sure it's okay to proceed. Okay, everybody, it's 3 o'clock. We're back from our recess, and it appears that the power situation in the city of Santa Fe has resolved itself. But let's check in with everybody first, just to make sure that we're able to proceed, and the parties that need to be here are, and likewise the witnesses that need to be here are able to join us as well. So, Mr. Hayden, I admitted you a few moments ago. Can you hear me? Are you able to connect?
I am, and thank you for that, hearing officer. We're ready to go.
Excellent, excellent.
Sorry, Mr. Hearing Examiner, Ms. Lynch
Yes.
sent me a message that she's in the waiting room.
Okay, let me, don't see her there. I may have admitted her.
I don't see her there either.
Well, my next question was just to check in with you, Mr. Elliott. Obviously, you're here and connected, so that's confirmed. And Miss Amer, is she joining us, Mr. Elliott, as well?
She's listening.
Okay.
Mr. Hearing Examiner, I'm at that doctor's appointment, and I'll
Oh,
be
yes.
back on. I'll be back on when it's over, but I'm gonna listen while I'm in the waiting room here.
Excellent, excellent. Thanks. Thank you, Miss Amer. Thank you so
Yeah.
much.
Bye.
Do we see Miss Lynch, hearing examiner Gecko?
I still don't see Miss Lynch in the waiting room.
Mr. Hearing Examiner, I had sent Ms. Lynch a text message just to let her know we were back on, and she said I need to be let back in. Can you ask? Oh, she said my computer shuts down randomly, so I'm not
Oh, no.
sure if she's trying to get in.
Yes, I think hearing examiner Gecko and I have just been monitoring the waiting room and haven't seen her logged in there yet. So we will just give her another minute and see if see if she can get connected.
I'll let her know.
There we go. I see her now.
Great, thanks.
Excellent.
Also, I've just for everybody's situational awareness, the YouTube is still on, and so I just verified that it's working. So we're on YouTube.
Yes, that's right. For all participating, the YouTube stream was able to be preserved. So it's been continuous since this morning. Hi, Miss Lynch, are you connected?
I'm connected, and at 3, I had hit the wrong Zoom link, so I apologize.
No worries, no worries. Okay, well, good to see you. So just to check in, is everybody here that we know of? Obviously, the people that aren't here can't answer that question, but I think all of us are here. Is that correct? Large customer group. Mr. McMillan is here from OPL. Miss Lynch from CCAE. DOJ is here. Miss Clark from Walmart. Mr. Walker from Targa. SPS with Miss Hardy is here. Staff is represented. And I believe we are able to proceed. So just picking up from where we left off before our extended recess, I believe Mr. Hearing Examiner Gecko had some continuation of his questions for Dr. Gigax. So if there's not anything else to proceed with, I think we'll just continue in that fashion. And the floor is yours, Hearing Examiner Gecko.
Good afternoon, Dr. Gigax.
Good afternoon, Hearing Examiner Gecko.
Yesterday during the hearing, I asked some questions with relation to what kind of adjustments are made in a situation where a commission wants to consider a situation where maybe, and this is with respect to no determination in this case, of course, at this point, or even necessarily, but when it needs to be taken into consideration of trying to make a change or a decision that institutes some kind of rate making or adjustment or something of that sort that ultimately, because of the regulatory compact, doesn't come back around to ultimately affect the ratepayers. Like, are there tools out there? I think I use the analogy of toolbox for a situation where it's been determined that a company is at fault, and you're looking for a solution that addresses that without harming ratepayers, while taking into consideration that movements to ROE and equity ratios and such all affect the way that that company might be rated, by rating agencies and such. And given your experience, do you know what tools might exist in that kind of toolbox?
Now, when you talk about utility at fault, what do you mean?
Like, I brought up an example where there's been a lawsuit filed, and the aim of that one piece of that lawsuit is allegedly to hold ratepayers harmless for fault. So we could think back to like a California fire, and the company has been found to be negligent in its transmission line, and in that case, ultimately there was bankruptcy there. I can't imagine that's great in a long-term respect for the ratepayers and what their rates end up being in the service they receive. And so if you were required to not have cost impacts ultimately or negative impacts on ratepayers, but you wanted to implement some kind of solution that isolated the increased costs to the utility without ultimately being passed through to ratepayers in some way through the regulatory compact. Are there tools for doing that? Do you know of any?
Not offhand. I would think if the costs were not included in the previous rate case, then the utility would have to file for another rate increase, and there would be a whole process to determine if that was just and reasonable.
Can you repeat that, Dr. Giax?
Sure.
I don't think I'm the only one that leaned in. There was a little bit of sound issue there for a second. I wasn't able to hear.
Is that on my end?
Yes, sir.
Yes, Dr. Gigax, I think there might be another source of audio. Maybe you have YouTube streaming on your computer or something.
I don't think so. Let me check. No, I left the YouTube before I got on the Zoom. I don't know what's.
And it may be that it's just, I'll lean in closer and turn my volume up. I just wasn't able to do that immediately right when you were speaking. And so you can see if you see anything, but if not, I think we have enough sound. We'll probably be able to move forward, though Mr. Lee will be the ultimate determination of that decision.
Okay.
Great.
So to me, what I was saying is that if this additional cost was not in the current rates and didn't come up in the previous rate case, then it seems like the utility would have to, other way to recover that would be to file for another rate increase. And then the process would protect the customers because the process, we had due process. But besides that, I can't really think. If it's not in a rider, then I don't know how else it would be picked up.
And so it sounds like it becomes a measure of somehow adjusting rates to not have those costs pass through in rates to the ratepayers.
That's correct.
Okay. And if those were tied to cost of service, then that cost of service would be presumably, in order to maintain reliable service, that would come from the shareholders in that case then? Is that how that would work?
Yeah, in the interim, because you can't change the base rates except to the next rate case. So yeah, that seems like that'd be the only way to recover those costs.
Okay.
In the interim.
Okay. Okay. Thank you. Thank you for that. Are the rate increases the rate increases in this case higher than what you're generally accustomed to in rate cases in New Mexico over the last 15 years? And I understand there might be reasons for that, but just on a straight understanding of the kind of increases that are being requested in this case, even granted in the stipulation that they're higher than what we're accustomed to seeing.
Yes, and let's see. What I have here is a table that I put together for the El Paso electric rate case. And it goes back to 1, 2, 3, 4, 5, 6, 7, 8, the last 9 rate cases.
Mm-hmm.
And the average utility proposal for residential class is about 19.5%.
The average proposal for a rate increase?
Proposal. Yeah. And then the average from the final order is for SPS is closer to 15%. So
overall,
15% for the residential.
For the residential, okay.
Yes, yeah. So what I did is I looked back specifically to SPS's last 4 rate cases, and what I found was that overall, SPS received on average of 58% of what they asked for. Okay, so what the commission ordered was turned out to be 58% of what they asked for. And the average residential increase was around, let's see, 15 or so, 15 to 16%.
Okay.
So I kept an eye on that. And for my evaluation of whether I believe the stipulation was just and reasonable, I compared it to past rate cases in New Mexico, as well as the SPS's specific past rate cases.
Okay.
And
Okay.
by that comparison, I concluded that the what was in the stipulation was reasonable.
Okay. Thank you for that. That's helpful. I can look. And then my last question is, I'm curious about if when a move is made with, do allocators change often from one rate case to the next? Is that a common thing, or is it something that is rare?
Actually, that's a very good question. And I asked myself that same question in this case. Because of the statements in different testimonies that a lot of the growth was due to the large customers, specifically in the oil and natural gas industry. And so I was concerned about whether the allocators were picking that up. And I asked SPS a discovery question, specifically response to NMDOJ 1-4. And what I found was since 2019, so that would cover 3 cases, including this one. When you look at the average excess demand for CP for transmission, and the average excess demand for CP for production, and then the energy at source allocators. So when you look at those 3, and those are the 3 primary allocators, what I found was that the average of those 3 for the residential class since 2019, the percent allocator actually decreased by 40%, which is a significant decrease. Residential heating class allocator decreased by 37%. So 40% for the residential, 37% decrease for the residential heating, and then a 25% decrease for the small general service class. Conversely, the primary general service class allocators increased by 32%, and the transmission class allocators increased by 33%. So what that told me was that, because I wanted to make sure it was being picked up at the allocators, that the growth in the large customer classes was in fact being picked up by the change in those allocators. So your question is a very good one. I would have been concerned if those allocators didn't change since 2019. I hope that answers it.
I think it answers more. My question was more with respect to, I hear these naming conventions, of like a AED 4CP and a 1CP, and that they change, and there's testimony about whether it's right to change that now or whether later, or whether it's used. And I just didn't know if it was, I know you testify in a lot of cases, and whether those are pieces that move with regularity or whether they are more stable across time.
Okay, fair enough. You're talking about the allocation method.
Thank you.
Yes, yeah. And so generally speaking, and I've worked on about 19 rate cases in New Mexico, and by and large, the companies have stayed consistent in terms of their methodologies that they've used in previous rate cases. If that's not the case, then that'll come out either in their testimonies of why they changed it or through discovery. So if there was a change, then there was an ample justification on the part of the utility. But more often than not, the methodologies used in a particular rate case, and in the cases I've worked on, are consistent with what the utility used in the past.
Okay.
That's the first thing I look at in terms of their class cost of service study.
Okay, that's helpful.
And indeed, in this case, the allocators that SPS used were in fact the same as what they used in the previous handful of cases.
In the application, correct?
Excuse me?
In the application you're referring to, they were the same?
Yes, in the application. Yeah.
Okay. Okay. Those were my questions. And as always, I learned something by being able to ask you a few questions. So I appreciate it. Thank you very much.
Thank you, Hearing Examiner Get-Go. It's always a pleasure.
Thank you.
Thank you, Dr. Gygax. Just seeing if Mr. Hayden has any follow-up for you, given Hearing Examiner Get-Go's question.
Thank you, hearing officer. No redirect, no.
Thank you. Okay, so Dr. Gygax, you may be excused.
Thank you, Hearing Examiner Schaefer.
Thank you. Take care.
Thank you.
Okay, so I don't believe that there's any questions for NMDOJ witness Mr. Bandick. Is that correct, Hearing Examiner Get-Go?
That is correct.
And just to confirm, I believe Ms. Amer stated earlier that staff did not have any time reserved for cross-examination. Is that correct?
Yes.
Thank you, Mr. Elliott. Okay, so Mr. Hayden, I believe that you have admitted, we've gotten the testimony of Dr. Gygax and Mr. Bandick admitted. So in that case, unless there's anything else, I believe there's your presentation of witnesses is complete.
Thank you, hearing officer Schaefer. Appreciate that. We're done then.
Okay, thank you so much, Mr. Hayden. Okay, so now just confirming with CCAE and Ms. Lynch that Mr. Eubanks is available tomorrow in case that's needed. Is that correct?
That is correct, yes.
Excellent. Okay, so then we'll proceed with the arrangement that we discussed yesterday evening and today, this morning, where a large customer group will be presenting its witnesses and then followed by OPL. So, Mr. Rushoff, I understand that you'll be presenting the witnesses for New Mexico Large Customer Group.
Yes, that's correct.
Okay, is your witness, I believe Mr. Bieber, I admitted him, and I also admitted Mr. Garrett, and we waived the appearance of Ms. Hashelman because no parties had questions, nor the hearing examiners. So whichever witness you would like to call first, Mr. Rushoff, we are ready.
Thank you. So first we'll call Justin Bieber as our first witness. I wanted to clarify, should we be admitting all of our hearing exhibits before we get to Mr. Bieber? I think is how we were
Yes, let's do
proceeding.
that. Yes,
Okay.
thank you. Thank you for that. Let me just go to the Dropbox and make sure that we have everything admitted. Okay, go ahead, Mr. Rushoff.
Okay. So the New Mexico Large Customer Group had 6 exhibits. The first is New Mexico Large Customer Group Exhibit number 1, which is the direct testimony and attachments of Justin Bieber.
Are there any objections? It's admitted.
The next was NMLCG Exhibit number 2, which is the direct testimony and attachments of David J. Garrett. And just to clarify, Mr. Garrett was testifying on behalf of the New Mexico Large Customer Group and Occidental in this proceeding, but we've marked that as an NMLCG exhibit for efficiency.
Okay, thank you. Are there any objections? It is admitted.
Okay, next is NMLCG Exhibit number 3, the direct testimony and attachments of Celia B. Hashelmoon.
Are there any objections? It is admitted.
NMLCG Exhibit number 4 was the stipulation testimony of Justin Bieber.
Are there any objections? It is admitted.
Okay, NMLCG Exhibit number 5 was the stipulation testimony of Celia Hashelmoon.
Testimony in support of stipulation.
Yes.
Yes. Are there any objections? It is admitted.
And then NMLCG Exhibit number 6 was the rebuttal testimony of Justin Bieber in support of the stipulation.
Are there any objections? It is admitted. Thank you, Mr. Rushoff. You may
Thank you.
call your witness.
Okay, the NMLCG calls Justin Bieber to the stand.
Hi, Mr. Bieber, can you hear me?
Yes, I can.
Well, good afternoon. Thank you for joining us. I'm hearing examiner Schaefer, joined by my co-hearing examiner Getko. The first thing we'll do is you'll be sworn in by the court reporter. He'll take a moment to get situated, and then he'll swear you in.
Mr. Bieber, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Please
Go
proceed.
ahead, please.
Thank you. Go ahead, Mr. Rushoff.
Thank you, and good afternoon, Mr. Bieber. How are you?
I'm well, thank you.
Thank you. Thanks for joining us. Could you please state your name for the record?
Yes, it's Justin Bieber.
Okay, and we had previously, just a moment ago, admitted exhibit number 1, which is your direct testimony, NMLCG exhibit number 4, which is your stipulation testimony, and NMLCG exhibit number 6, which is your rebuttal testimony in support of the stipulation. Can you confirm that you are the author of those 3 exhibits and pieces of testimony?
Yes, I am.
And if I asked you those questions in that testimony today, would your answers be the same?
Yes, they would.
Okay, I wanted to ask, you've been listening to this hearing, and I know early in the hearing, Chairman O'Connell asked a question that he wanted to hear from all parties about. So I wanted to ask you that question now. And the question is being, on behalf of the customer interests that are signatories to the stipulation, in your opinion, is the stipulation fair in a world where New Mexico customers will be paying higher rates than Texas customers for the same service?
Thanks for that question. As a threshold matter, I haven't analyzed SPS's rates in Texas, so I'm not aware with certainty whether rates are higher in New Mexico or in Texas. However, my understanding of Mr. Trowbridge's testimony yesterday is that New Mexico and Texas residential rates are generally comparable, and that the New Mexico residential rates have actually been lower since 2021. And that was in part attributable to more significant subsidies for residential customers in New Mexico. However, I also recognize that given the rate increase that may result in this case, there's a possibility that the comparison between New Mexico and Texas rates may change. However, even if New Mexico rates become higher for a time, that fact alone does not necessarily mean that they are not fair. SPS operates an integrated system, and the cost and rates for each of the jurisdictions can differ for legitimate reasons. For example, there are currently more stringent emissions requirements in New Mexico compared to Texas. There are different customer and load characteristics and different weather and usage patterns. I also recognize there's been considerable discussion in this case about the use of the future test year in New Mexico, whereas it's not done the same way in Texas. And I agree that the use of a future test year is an important factor in rate making, but the use of a future test year by itself does not necessarily result in higher rates in one state versus the other. I would note that the future test year has been in place in New Mexico for some time, yet as we heard yesterday, the New Mexico residential rates have been lower in New Mexico since 2021. Rate making, considers totality of the circumstances. And so while it's true that considering a future test year with additional costs of investments that are not in the base period may by itself directionally put upward pressure on rates, there's a number of other factors that also impact rates. For example, in the future test year, if there's also an increased amount of load, that's going to spread the costs over more billing units and put some offsetting or downward pressure on rates, because a higher amount of load results in a higher amount of current revenues. And for a given revenue requirement, if you have higher current revenues, that's going to change your revenue deficiency. There's also a lot of other factors such as ROE, return on equity, riders that recover revenues outside of base rates, and other adjustments and to expenses in the revenues that you would consider in the context of a future test year. It's my view that fairness should be evaluated by whether the rates established for New Mexico customers are just and reasonable based on the costs, revenues, customer impacts, and other circumstances that are on the record, reflected on the record. Texas regulators and parties must perform a similar analysis under the circumstances in Texas, and the two jurisdictions might use different methods and reach different rate levels without either result necessarily being unfair. Based on my review of the record and the compromises embodied in the stipulation, in this case, I believe that the stipulation produces a reasonable result for New Mexico customers. But of course, the ultimate determination of that will rest with this commission.
Thank you for that. I don't have any further questions for Mr. Bieber, so he's now available for cross-examination.
Thank you, Mr. Rushoff. Staff, I see that you had reserved 17 minutes of time to cross-examine Mr. Bieber. Is that still something you wish to do?
No, we have no questions for Mr. Bieber. Thank you.
Thank you, Mr. Elliott. So no cross, no redirect. Then I turn the witness over to Mr. Hearing Examiner Gecko if he has any questions for Mr. Bieber.
I just have one or two questions. Good afternoon, Mr. Bieber.
Good afternoon.
Um, you're providing testimony on behalf of how would you describe the client that you have their energy resources?
I'm sorry, how would I describe their energy resources?
Like, are they a firm load, large load? You know, these words that get bandied around. How would you describe your client in terms of the way that we refer to customers being in certain rate classes? How would you describe that?
Yeah, so the New Mexico large customer group consists of large customers primarily on the general and transmission voltage rate schedules.
And then I see you testified on allocation and such, and so I understand that you understand rate setting. Is that fair?
Yes, that is.
And what I don't know, it may be in testimony somewhere, is you know, I've seen different rates used, and not for SPS, but a rate class created for a particular very small subset of customers. I've heard and don't have great knowledge of situations where, you know, certain contractual rates are set for certain customers. Are there agreements for particularities as to the application of a rate class's rate for particular customers that you are testifying on behalf of?
So to clarify the question, are you asking if the customers that are part of the large customer group have special contracts with terms and rates that differ from that of the primary rate schedules that they take service on?
Yes, that's an excellent clarification of my question.
I'm not aware of any such contracts.
And so, if the customers that you represent were to need to exit the market in which they participate or change their level of participation in that market, there are not obligations for, I don't know, are there obligations for minimum payments to be made in time periods after which a portion of their demand goes down? Like, for example, if they have demand set at X and then it becomes X minus 20% pretty suddenly because of some shock in the world, for example, is there an obligation in any way to maintain payments that are equivalent to what they've been paying based on their average load over the last year, for example? Anything of that sort?
Yes. So my understanding is that both the primary general service rate schedule and the transmission general service rate schedules both have a demand ratchet, which essentially bills customers on that schedule for a proportion of the highest demand that they've experienced in the past year.
Okay. And okay. And that looks back 11 months, correct?
I'd have to check if it's 11 or 12. I think my recollection is it's the 11 preceding months, so it encompasses a period of 12 months.
So as long as you're still a customer and you're a member of one of those two rate classes, that ratchet, does that update monthly? Or so let's say we have this shock and it goes down by 20% in January. That ratchet is going to hold it per the stipulation at 70% of the last 11 to 12 months. And then when we get to February, does it now incorporate January's demand into the calculation of what the 70% on the ratchet is for the purposes of February billing? Or is that how it would function?
I might need to take a look at the the detailed language in the tariffs, but my general understanding is it's based on the maximum that occurs during the preceding 11 or 12 months. So if you have only 1 month where that goes down, it could impact essentially the maximum that percent is based on, but only to the extent that that month was the maximum. But you would still have the other months included in that period that, may be essentially the basis for that ratchet.
Okay. And so so the ratchet is based on the maximum within the last 11 months, 12 months, subject to check. And so as you move forward, you're always just looking back that period. And so there's a shifting over time, of course, of what that maximum demand is. And so if a customer were to go to 10% or go to 80%, sorry, in January and then stabilize at that point, X number of months later, that would eventually become what the ratchet is based. That sets your floor for what the customer is paying. Is that a correct understanding? And you can ask me to clarify. I'm struggling a little bit with it. I'm sorry.
Yeah, well, when you say, goes to 80%, I guess the question would be 80% of what? Because I think the demand ratchet is based on, the maximum demand in any of those trailing months.
So if there was a maximum demand set in like August of 2025, and then, when we get to January of 2026 and, the demand in that month is lower than what it was in August 2025, and same for February, going forward, let's just say it's the same for each month going forward. But in January and all those months going forward, it's 80, that maximum demand. If we compared that to what the August 2025 demand was, we're at 80%. And so once August 2025 is 11 or 12 months in our past, so when we get to September 2026, in this example, we now have that minimum rate based upon a demand that is 80% of what it was in August 2025. Is that a proper way of understanding how that functions?
Yes, that would be correct, as long as the demand in those 12 months since August 2025 was never more than 80% of the August 2025 level.
Okay. Okay. And do you participate in constructing large load, you use the word, special contracts? Do you have expertise in special contracts?
Yes, I do.
And is that stability of demand something that's taken into consideration in formulating as special contracts as a possible inclusion in them?
Yeah, so I didn't testify about special contracts in this case, but generally, in my experience, it is important to have some certainty as to what the level of demand will be to ensure that the revenues are sufficient for the purpose of serving that customer in a unique circumstance.
Okay. Sorry, I made the assumption that since the stipulation sets a 6-month timeline for a working group and for SPS to submit a large load tariff, and sorry, it's not in your testimony. Could I ask one more question about it though?
Absolutely.
Do you know what kind of timeframes are looked at? I'm curious where that might exist of considering in those special contracts, kind of like how far out obligations go. Is there a range from 1 month to 10 years across different states, or has it centered on a certain point as to how those are constructed?
Yes. So I've been involved in a number of large load tariff dockets in other jurisdictions. And, the ranges do vary by jurisdiction. I believe kind of some of the latest benchmarking I've been looking at is there's a lot of minimum contract terms that are being approved in other jurisdictions in the range of 10 to 15 years. I've seen shorter, I've also seen longer, but that seems to be where a lot of the jurisdictions are landing.
Okay. Okay, that's the extent of questions that I had. I appreciate you sharing that information and filling out my awareness. Thank you. Thank you.
Absolutely.
Thank you, Hearing Examiner Gecko. Thank you, Mr. Bieber. I'll just check with you, Mr. Rushoff, if you have any follow-up questions for the witness based on the hearing examiner's questions.
Yes, just one clarifying question.
Please go ahead.
Mr. Bieber, a moment ago, you testified that you have experience with special contracts. Is that correct?
Yes, that's correct.
And to clarify, do you have experience working on special contracts with SPS for New Mexico large customer group clients?
No, I do not. I have experience with special contracts in other jurisdictions.
Thank you. That was my only question.
Thank you, Mr. Rushoff. Unless staff has any last-minute desire to cross-examine this witness, I believe, Mr. Elliott, you okay? Okay, excellent. Thank you for confirming.
I don't have
But-
I don't have any cross for the large customer groups witnesses.
Okay, excellent. Just confirming because, once we excuse a witness, that's kind of the end. Thank you, Mr. Elliott. Thank you, Mr. Bieber, for your diligence and participation. Very much appreciated. You may be excused.
Thank you.
Okay, Mr. Rushoff, I believe we're ready for Mr. Garrett.
Yes, I would call David Garrett to the stand.
Thank you. And I believe there's Mr. Garrett. Hi, Mr. Garrett. Can you hear me?
Yes, I can. Can you hear me?
Yes. Thank you for being here with us. My name is Patrick Schaefer. I'm one of the hearing examiners here, joined by hearing examiner Gecko. Before we get started, our court reporter will swear you in. He'll get situated and then have you raise your hand and say the oath momentarily.
Mr. Garrett, would you please raise your right hand? You solemnly swear the testimony you're about to give, no matter how pending, should be the truth, the whole truth, nothing but the truth?
I do.
Thank you. Go ahead, please.
Good afternoon, Mr. Garrett. Could you please state your name for the record?
My name is David Garrett.
A moment ago, I introduced New Mexico Large Customer Group Exhibit Number 2, which is your direct testimony and attachments in this case. You submitted that testimony both on behalf of both the New Mexico Large Customer Group and Occidental in this case. Is that correct?
Yes.
And if I were to ask you the questions in that testimony today, would your answers be the same?
Yes.
Okay. And the New Mexico Large Customer Group would sort of, I suppose, rest on Chairman O'Connell's question with Mr. Bieber's answer. So given that, I don't have any further questions for Mr. Garrett, and he's available for questioning.
Thank you. Thank you, Mr. Rushoff. And as we heard from staff, there won't be cross-examination for this witness, so no redirect. I defer to hearing examiner Gecko if he has any questions for this witness.
I have one question. Good afternoon, Mr. Garrett.
Good afternoon.
And it's because your testimony is referenced elsewhere and it points to attachment DJG-19 and you're direct. which is starts on page 194 of the PDF, more or less.
194.
If
Oh,
you go by
I
the PDF pages, yeah. I'm sorry,
yes.
sir. Yeah. Are you with me, or I'm sorry, I interrupted you a little bit.
Oh, I was confirming that I do see that.
Okay. And I have a note that that you have noted that for Cunningham Unit 2, there's a depreciation expense on page 1 of $11 million, 144,407. And I'm not necessarily seeing that number there.
Yeah, I don't. I didn't have an adjustment to Cunningham Unit 2 in my direct
Right.
testimony.
Yeah, and the number between the quote I took and what's here, I don't see it, but I think it's a little bit besides the point. My question is simply this: is the reason I honed in on that is because there was testimony elsewhere in the case that that plan is closing, is my understanding. And so I understand that it's a depreciation expense. Does it have a depreciation expense during the future test year?
It was not included in the 2027 depreciation study from the company. So I don't
Okay.
believe so.
Okay. Then that's the extent of my question, because my question was based on other testimony, and that will help me look elsewhere. I appreciate it. Thank you.
Thank you.
Excellent. Thank you, Hearing Examiner Getco. Just checking with you now, Mr. Rushoff, if you have any follow-up questions based on Hearing Examiner Getco's questions.
No, I do not. Thank you.
Okay, excellent. Well, thank you for your time and participation in this case, Mr. Garrett. It's very worthwhile and much appreciated. And with that, I believe you may be excused.
Thank you.
Thank you, Mr. Garrett. Now, Mr. Rushoff, I believe that completes the presentation of your witnesses.
That is correct.
Thank you so much. Okay, actually, we're in a good, perfect place, perfect timing. It seems the afternoon in some ways is going well. Let's take a 10-minute break for Mr. Lee and for all of us to just get a bit of fresh air, and then we'll go ahead with our last hour. I believe I see Mr. Lee has just I'm just admitting Mr. Lee for your awareness, Mr. McMillan, and we'll take a recess until 4 p.m. So that's 9-10 minutes, and we'll see everybody back then. Thank you so much. Okay, good afternoon again, everybody. It just turned 4 o'clock. We are back from our recess and on the record. I believe that we are ready to proceed with OPL. Is that correct, Mr. McMillan?
Yes, Your Honor.
Excellent. Well, as is our practice here at this hearing, would you like to move to enter OPL's exhibits into the record?
Yes, Your Honor. OPL moves to enter OPL Exhibit 1, which is the direct testimony of Jonathan Lee.
Any objection? It is admitted.
OPL moves OPL Exhibit 2, which is the testimony of Jonathan Lee in support of the stipulation.
Any objection? It is admitted.
And OPL moves OPL Exhibit 3, which is the direct testimony of Billy LeConte.
Any objection? It is admitted. Okay, thank you, Mr. McMillan. I believe we are ready for your first witness.
OPL calls Jonathan Lee.
Hi, Mr. Lee, can you hear me?
Yes, Hearing Examiner Schaefer, can you hear me?
Yes, good to see you again. Thank you for being here with us. I think you know the procedure. Our court reporter, Mr. Lee, will swear you in, and once he gets situated, he will let you know when he's ready.
Sorry, Mr. Lee, are you speaking? I can't hear you.
No, sir. Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, nothing but the truth?
I do.
Thank you. Go ahead.
Thank you. Go ahead, Mr. McMillan.
Mr. Lee, could you introduce yourself, please?
Yes, my name is Jonathan Lee. I'm an associate of J. Pollock Incorporated, appearing on behalf of OPL.
Okay, Mr. Lee, you may be aware that the chairman has asked us to ask each witness a particular question, so I'm going to pose that question to you now. As a witness testifying on behalf of OPL, how do you view the fairness of different rates being paid by customers in Texas versus customers in New Mexico?
I think it's fair and reasonable for customers of SPS in different jurisdictions to pay rates that would differ. Specifically, I say this because the method by which SPS determines these rates is an industry standard. Specifically, the company determines a total company revenue requirement and then allocates it to each jurisdiction based upon jurisdictional allocation factors. At that point, it then allocates costs among rate classes with retail-specific class allocators. And ultimately, these amounts allocated to each class go into a specific rate design. As I mentioned before, that's an industry standard, and they employ this practice in both jurisdictions, New Mexico and Texas. To the extent that there are differences, they're mainly reflective of different usage characteristics in each state. I'd also point out some other driving factors, which are timing differences, both with respect to when rate cases are filed and an issue that's come up a few times in this rate case of historical versus future test year. Another consideration that's been of growing concern as of late is different planning criteria with respect to resource types in between New Mexico and Texas.
Okay, well, thank you for that response, Mr. Lee. And Your Honor, OPL presents Mr. Lee for cross-examination.
Thank you, Mr. McMillan. Staff, I see you have 25 minutes here reserved for cross-examination of Mr. Lee.
We're going to waive. Thank you.
Okay, thank you, Mr. Elliott. So no cross, no redirect. I then now defer to hearing examiner Getco to see if he has any questions for this witness.
Yeah, I have one question. I was working on getting it real defined, so it might not be super defined.
Maybe we could work through it together.
That'd be wonderful. Thank you, Mr. Lee. Good afternoon.
Good afternoon.
So in your testimony, in your direct testimony on page 14 for sure, you testify to this element of this that has ultimately ended up in the stipulation about the use of a 1 CP load factor, and it's consistent with the typical application of the AED method, and you refer to the NARUC manual. Do you recall that?
Yeah, that's correct.
So yesterday during some questioning, and this is what I was trying to locate and I didn't get to, is that was being discussed, and it was shown, I believe it was Mr. Trowbridge that, and when he was showing it based on a question by one of the parties, it showed a little bit over like a $2 million shift to the residential class because of it, if I remember correctly. Were you watching that testimony by Mr. Trowbridge too?
Yeah, I was. I can't testify to the specific numbers, but I do recall that discussion.
And what came out there, and I asked a question, I believe, along the lines of, okay, so we've got testimony that Dr. Blank has said this would be appropriate for the next rate case. There's a working group to work on this. The dollar shift isn't that great. And then I think a statement was made like, you know, if we hadn't done this, there's a good possibility the stipulation wouldn't have happened. And were you also, do you recall a statement of that sort to some degree?
I don't recall that specific statement that the stipulation wouldn't have happened were it not for that.
Not that strongly.
Okay.
Is not how I remember the statement. And this is why I wanted to grab it. I remember some statement of, you know, I just don't want to say, it wasn't said the stipulation would not have happened if this didn't happen. But what I understood from the statement was it was an important piece in the stipulation. And so reading your testimony a little bit and seeing, you know, it's a reference to a standard in a NARUC manual. And having spoken with Dr. Gigax and asked the question about changing up allocation methodologies and that, you know, reasons need to be given, or he didn't say need to be given, but they're generally given. Why is this an important move? If there is a working group for it that's going to assess it, it makes what I've understood to be a small monetary difference. It's something that's been standard for a long time, and they don't generally shift that much. Can you help me understand the importance of this?
Yeah.
Yeah.
Sorry, I didn't mean to cut you off. Were you done with your question?
That was it. Yeah, thank you.
Yeah, no, I think that this is just essentially a standardization. The AED 4CP method as calculated by SPS, I think is nearly correct. It's just that one clarification, essentially, that would make it comport with established practice.
And it's been established practice, by my understanding, quite a way. And the 4CP has been established for a long time in New Mexico, is my general understanding. Do you have knowledge with respect to that, as far as SPS is allocation methodologies go?
When you say 4CP, do you mean the use of 4CP with an AED or with specific regard for the load factor weighting?
My understanding at this point is the most significant change here is this one to the 1CP load factor that's used in how you apply the AED 4CP. Is that correct?
Yeah, so my understanding is that many of these rate cases have been settled, and this issue's been punted down the line for a little bit. I think that kind of as a matter of inertia, I think SPS has kind of retained this 4CP load factor weighting for a few rate cases, and similarly, consultants on behalf of OPL have addressed this issue in their prior testimony as well.
Okay. And so besides the monetary differences that Mr. Trowbridge walked us through, with an understanding that there's a rate case that Ms. Lees has testified that will be filed with some imminence for SPS again, and understanding that there's even in the testimony of Ms. Johnson and rebuttal testimony to the stipulation, we see there's like a little bit over a $2 million bucket that was kind of a slush fund and not tied to anything in particular. And I see $2 million there, and I see $2 million with Mr. Trowbridge explaining the impact of this 1CP through when you're applying the AED 4CP, using it to weight average demand. Why is it so important to happen now? I mean, it's been punted down the line. There's all these things set out to deal with it. There's controversy about it. Stability is something that folks generally like. Why is it so important right now? Like, what's behind that?
Yeah, I mean, I wouldn't say that there's special significance with respect to the timing as to why it had to be right now. If this change had been made in a prior rate case, I mean, we would have been satisfied with that change then as well. I think this is just an issue of import for us just because we think it's appropriate to get the calculation of the AED 4CP allocators right. When that change occurs, whether it was in the last rate case, this rate case, I think we would be satisfied as long as that change is made.
Okay. I think that's enough. I've asked about it from this way, and I appreciate your answers. And yeah, I appreciate you speaking to me today. So thank you for coming in. Thank you.
Yeah, thanks for the opportunity to share my perspective.
Thank you, Hearing Examiner Getko, and thank you, Mr. Lee, for your contributions. Mr. McMillan, do you have any follow-up questions for your witness, given Hearing Examiner Getko's inquiries?
No, Your Honor.
Thank you, Mr. McMillan. Okay, well, seeing that all parties have been able to cross-examine Mr. Lee, and hearing examiners have had an opportunity to make inquiries as well, I can excuse you, Mr. Lee. Thank you so much for all your hard work and diligence.
All right. Thank you for your time today, everyone. Have a good afternoon.
Thank you so much. Thank you.
And with that, Your Honor, nothing further from OPL.
Excellent. Thank you, Mr. McMillan. We are moving along at a good pace. Okay, so after large customer group and OPL, our next intervener in order of intervention is CCAE. And I would just inquire with Ms. Lynch if Mr. Eubanks is available.
Yes, he is. And so you'll just need to let him in.
Okay.
If possible. I think.
I haven't seen it. Oh, there he is. Perfect. Okay, great.
Miss Lynch, could you spell Eubanks for me, please?
EUBANKS.
Thank you very much. Go ahead.
Yep, you're welcome.
So, Mr. Eubanks, can you hear me?
Yes, thank you. Yes, can you hear me?
Excellent. Excellent. Hello, good afternoon. Thank you for joining us. Mr. Eubanks, we're just going to take care of a procedural matter first and get CCAE's and your testimony admitted. And then the court reporter will swear you in once he gets situated. So first, I'll just ask Ms. Lynch if CCAE has any testimony that they would like to admit.
Yes, we have 2 exhibits that we would like to admit.
Please proceed.
Okay. Good afternoon, Mr. Eubanks.
Good afternoon.
Can you please? Oh, yes.
Sorry, we can just stipulate and you can identify the exhibits in the Dropbox that you want admitted, and we'll just check if there's any final objection, and then have those exhibits admitted, and then we can proceed to swear Mr. Eubanks in, and then he can answer any question on direct that you may have for him, and then we can check with staff if they have cross, et cetera, et cetera. So we'll do the exhibits first.
Okay. Mr. Eubanks, can you identify CCAE Exhibit 1? The direct testimony of Alex Eubanks on behalf of Coalition for Clean, Affordable Energy?
Yes,
Did you prepare it?
I did.
Are there any changes you would make to it?
No, there are not.
Is it true and accurate?
It is.
And you adopt it as your direct testimony today?
Yes, I do.
Okay. Do you see CCAE Exhibit number 2?
Yes.
That is titled Stipulation Testimony of Alex Eubanks on behalf of Coalition for Clean, Affordable Energy. You recognize that?
Yes, I do.
Okay. Did you prepare it?
Yes, I did.
Is it true and accurate?
It is.
Do you adopt it as your direct testimony today?
Yes, I do.
And do you have any changes to make to it?
No, I do not.
Your Exhibit 1 included a number of attachments, AE 1 through 6. Is that accurate?
Yes, it is.
We would admit those pieces of testimony, Your Honor, if CCAE moves for admission of the exhibits.
Okay, yes, thank you, Ms. Lynch. Okay, so that's all we needed. Does any party object to the admission of CCAE Exhibit 1 or 2? No, they're admitted. Thank you so much. I'll just say again, for the record, it wasn't necessary to engage the witness there. It wasn't under oath yet, but all good. So now, Mr. Eubanks, the court reporter, as I said, once he gets situated, will swear you in, and then we'll proceed. Thank you.
Thank you. Sir, should I ask
I
him
need
the
to swear
chairman's question?
I need to swear the witness, please.
Okay.
Mr. Eubanks, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, nothing but the truth?
I do.
Thank you. Go ahead, please.
Yes, Ms. Lynch, you had a question? Oh, you just went on mute.
apologies. I was just going to ask him the chairman's question.
Yes, go ahead. Please proceed, Ms. Lynch.
Okay. Mr. Eubanks, in your opinion, is it fair, just, and reasonable that SPS customers in New Mexico pay different rates than SPS customers residing in Texas?
So I would say that the fact that rates differ between jurisdictions doesn't in and by itself establish that they are unfair. However, I did not conduct the comparative rate or jurisdictional allocation analysis necessary to determine whether the specific New Mexico, Texas differences in this case are fair, just, and reasonable. So I really can't offer a case-specific opinion. My testimony focuses solely on section 1.12 of the and the EAP.
Thank you. And with that, Your Honor, CCAE passes the witness.
Thank you so much, Ms. Lynch. Just checking with staff, I don't believe that any time had been reserved for the cross-examination of Mr. Eubanks. But again, just for completeness and thoroughness and due process, wanted to check, Mr. Elliott, if that had changed.
It has not. Thank you.
Thank you, Mr. Elliott. Okay, no cross, no redirect. Now I defer to hearing examiner Getco to see if he has any questions for Mr. Eubanks.
I just have a couple brief questions. Yes. Good afternoon, Mr. Eubanks.
Good afternoon.
Your direct testimony is you looked pretty closely at the EAP, at the Energy Affordability Program, correct?
That is correct.
And your original recommendation in part spoke about the consideration of funding it through a volumetric charge. Is that correct?
That is correct.
And so at your direct on page 17, you testify that a fixed monthly rider imposes the same charge on low usage and higher usage customers within the same class. And then that introduces issues of different customers that have different usage levels. If they all get that fixed charge, then it doesn't correlate with usage. I'm paraphrasing here to try not to take too much time. Is that a fair generalization, or would you want to clarify anything after I said it like that?
No, I think that's an accurate description.
So my curiosity is, and I know there's going to be a working group with respect to this, and your testimony focuses there on within the same class. Is it important to you to look at which class is funded as well? And I reference that, looking at your background, it says, my work includes evaluating energy affordability programs and assessing their impacts on low and moderate income households. And so I just kind of wanted to hear, and what your thoughts are. You interested in how this is funded with respect to different classes? Is that something of interest to you as an expert that is interested in these kinds of programs and their impacts on low and moderate income households?
I wouldn't say that it's not interesting to me, but it is not something that I decided to focus on in my testimony or make any recommendations for. I was, in terms of the cost recovery, my recommendation was solely intra-class volumetric. So that was where I was focusing. So I did not in my testimony tackle maybe what you are specifically, I think, leaning at. So yeah, I think that, yeah.
And so if that were of interest to you, you could bring whatever positions you have on that to the working group, or is that a closed issue as far as which classes fund that program in your consideration?
I mean, I think that the preservation, or not the preservation, but the inclusion of the working group in the stipulation, that is a place where I think that those discussions would be appropriate, especially after we have some data once the program is off the ground. That's one of the challenges of analyzing this, is because it has not been in effect yet. And so I think that the working group being formed 60 days after, assuming if the stipulation were to make it through, that would be an appropriate place for those considerations to be taken into account.
Okay. I appreciate you giving I just wanted to kind of fill out, because you have the most robust testimony on that program, and fill out a little bit of blind spot and understanding. And I appreciate you appearing today and for just a brief moment and answering my questions. Thank you.
Thank you, hearing examiner.
Thank you, Mr. Eubanks. Ms. Lynch, do you have any follow-up based on hearing examiner Getko's questions?
Not at this time.
Thank you, Ms. Lynch. Mr. Eubanks, thank you once again for all the time and effort you put into this case. It really makes a difference, and thank you for your time. You may be excused.
Thank you, Your Honor.
Thank you. Okay, so we're about half an hour away from 5 o'clock. I thought we'd just take a minute to talk about organizing some things before we move forward and get into day two. We still have some time to hear from some parties today, but I just wanted to also check in with parties. I see that FEALES is next, and Mr. James Lako has joined us. So I believe we will have time to certainly hear from that witness. The other thing I wanted just to check with the parties on is that Dr. McGovern has also joined from Walmart. Now, Dr. McGovern has only availability after 11 a.m. Tomorrow. Is that correct, Ms. Clark? Oh, I think you're on mute, Ms. Clark.
Sorry, I clicked the unmute. No, I believe that's LES's witness that only has availability after 11 a.m.
Oh, I'm sorry. Okay, thank you. It's been quite a day of circumstances. Okay, Mr. Lako, that's right, is only available after 11. Okay, so let's go ahead with Mr. Lako, and then we may even have some time if everything goes well to get to Dr. McGovern. Okay, Ms. Miller, are you ready to present your witness, or first of all to offer your exhibits into the record and then present your witness?
I am ready, Your Honor. I believe all of our exhibits, including the direct testimony of Mr. Lako, have already been admitted.
That's right. That's right. We did all of them. Okay, excellent. Okay, so Mr. Lako, can you hear me?
Yes, can you hear me?
Yes, good afternoon. Thank you for being here with us. You may have heard or seen before. You'll be sworn in by the court reporter momentarily once he gets situated.
Okay.
Mr. Lako, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not penny should be the truth, the whole truth, nothing but the truth?
Yes.
Thank you. Go ahead, please.
Hello, Mr. Lako.
Hello.
Can you please state your full name for the record?
James Lako.
And Mr. Lako, your direct testimony has already been admitted, but do you have your direct testimony in front of you, which is Exhibit 4 for FEA LES?
Yes.
Okay. And was that testimony prepared by you or under your direct supervision?
Yes.
And if you were to give this testimony today, would your answers be the same?
Yes.
And you have 2 attachments to your direct testimony. Were those 2 attachments prepared by you or under your direct supervision?
I mean, one of them is data requests or data responses, but yes.
Okay, thank you. And we have already asked Commissioner O'Connell's question from Mr. Gorman. So I tender Ms. Lako for questioning.
Thank you, Ms. Miller. I believe that staff, you had reserved 10 minutes of cross-exam for Mr. Lako. Is that correct?
It is, but we don't have any cross. I do have a question, Mr. Hearing Examiner.
Yes, go ahead.
Are each of the witnesses answering this question from the commissioner, or only one witness per party?
It's just the party. So the party can elect to have whichever witness answer the question.
Okay, very good. Thank you for clarifying.
Sure, thank you. And that also will comport with what hearing examiner Gecko and I anticipate with a post-hearing briefing order, where a party will also have the opportunity to answer that question. Thank you. Okay, so no cross-exam, no redirect. I then ask hearing examiner Gecko if he has any questions for this witness.
I'm making one note and I can answer that. I need about 30 seconds. I'm sorry.
No rush. Yes.
I guess I just have one question, I think. Good afternoon, Mr. And I'm Lako. Am I saying that correctly? So in your direct testimony, one piece that you addressed, and I understand there's a stipulation proposed here, was to amortize the rate case expenses over 3 years instead of 2. Is that correct?
Yes.
Is that correct?
Yes.
Okay. And that direct testimony was motivated by the possibility of some over recovery if those rates stayed in effect for more than 2 years, right?
Yes.
And so what I was looking at was, you testify there that the final order in SPS's last rate case, well, you also testified to that is actually what has occurred. based on the amortization period that was given in that last settlement in that rate case, that there's been an over collection of those rate case expenses.
When you
in
look
the
at them in
current
isolation,
rates.
yes.
I'm sorry, one
sir?
at a time.
My apologies.
Go ahead.
I didn't
Mr.
hear
Lake.
your answer, sir.
Yes, that's what I testified. When you look at it in isolation, that is what happened.
And so, just from my the last rate case was, when you say was issued in October 2023, was that the final order? Oh yeah, the final order in SPS's last rate case was issued in October 2023. And this rate case was filed. Do you recall the date that this rate case was filed?
Apologies, I don't know off the top of my head, but I mean, I was
Right.
comparing the date of the final order in that rate case to the expected final order in this rate case.
Okay. And what did you use as the expected final order in this case, in this rate case?
Let me see if I cited it in my testimony. Give me a minute. I believe you'd be able to find the expected final order date. I mean, that's often included as an item in the company's application. I'm just trying to see if I maybe.
Well, and maybe it's not the final order, it's that the rates would go into effect around December of 2026, is my understanding. Okay, so.
Yeah, I don't believe I cited a specific date. Okay, I'm quickly looking here.
So, a little over 3 years from final order to final order. I can do the rest of the math there. Sometimes at the last minute, I'm trying to determine whether I still have questions. And
take your time.
I think that's plenty. I can do math on time and understand the kind of risk that we may face for the same result, if that's a risk or whether that's appropriate. I understand there's different perspectives on that, but at least I can do the math and see that if based on a presumption as to when SPS will file their next rate case. And so I'm being a bit apologetic now. And so I appreciate you answering my couple questions and letting me focus down on that in real time. So thank you.
No problem. You're welcome.
Thank you. Thank you, Mr. Lako. I'll just ask if Ms. Miller, you have any follow-up questions for the witness, given hearing examiner Getko's questions?
Mr. Hearing Examiner, I don't believe so. I'm just waiting for co-counsel to tell me if there are any redirect.
Sure.
Okay, we do not have any redirect. Thank you.
Excellent. Thank you, Ms. Miller. Mr. Lako, once again, thank you for your participation, and I let you know you may be excused.
All right, thank you.
Thank you so much. Okay, I believe now we're ready for Walmart to present its witness. Is that correct, Ms. Clark?
Yes, yes, it is.
Excellent. Has Dr. McGovern joined us?
Yes.
Okay, I see her now. Hi, Ms. McGovern. Thank you for being here.
Thank you.
Okay, Ms. Clark, I believe first we should get the exhibits admitted into the record. Is that correct?
Yes, please.
Okay, please identify which exhibits you wish to enter into the record.
Walmart moves for the admission of Walmart Exhibit 1, which is the direct testimony of Dr. Jamie Lindsay McGovern.
Any objections? It is admitted.
And Walmart also moves for the admission of Walmart Exhibit number 2, which is the direct testimony of Dr. Jamie Lindsay McGovern in support of the stipulation.
Any objection? It is admitted. Thank you, Ms. Clark. Now, Dr. McGovern, the court reporter will swear you in once he gets situated.
Okay.
Dr. McGovern, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, nothing but the truth.
Yes, I do.
Thank you. Go ahead, please.
Would you please state your name for the record?
My name is Jamie McGovern. That's spelled McGovern.
By whom are you employed and what is your position?
I work for Walmart as Senior Manager Regulatory in Utility Partnerships of Energy.
Did you prepare Walmart exhibits number 1 and 2, which are your direct testimony and testimony in support of the stipulation?
I did, yes.
If I were to ask you the questions contained in those testimonies, would your answers be the same?
Yes, they would.
And Chairman McConnell has requested that parties answer a fairness question. Does Walmart have retail stores in SPS's Texas service territory that take service from SPS?
I believe we do. We have another Walmart employee that has worked in Texas more recently and knows the number of stores.
From Walmart's perspective as a customer, how does Walmart view the fairness of paying different rates in New Mexico and Texas for SPS service?
So I think Walmart probably likes to think of the term equitable as a good approach for the, sort of a proxy for fairness. And Walmart is always supporting the movement towards cost-based rates. We understand that there are rate shock considerations and all sorts of things that go into determining rates in different jurisdictions, along with things like renewable mandates, density, geography, these kinds of things. But highlighted is the sort of cost-based approach.
Okay, I pass the witness for questioning.
Thank you, Ms. Clark. Staff, I see that you have allocated 10 minutes for cross-examination of Dr. McGovern.
Staff is going to waive. Thank you.
Thank you, Mr. Elliott. I then ask hearing examiner Getco if he has any questions for Dr. McGovern.
I think maybe it's just one, maybe two.
Okay.
Good afternoon, Dr. McGovern.
Good afternoon.
In your direct testimony, and I'm referencing page 33.
Let me just pull that up.
Yeah.
Okay, I'm there.
So on lines 1 through 4, you, as part of your recommendation regarding large load tariffs, or what you refer to as very large load customer class, so VLL, very large load.
That's correct.
You provided a recommendation that until company conducts a cost of service study that includes the new VLL customer class, the commission require the company to track the costs imposed by and load characteristics of customer meeting these criteria. And up above in your testimony, you define those criteria.
Yes, that sounds right.
And as everybody knows, the stipulation includes a stipulation for a I'm turning now to section 1.20 of the stipulation, and
Yes, I see
it
that.
it states there that SPS will gather intervener input on the large load tariff before filing it. I don't see a provision there for an explicit working group, or I thought there was, but I don't see it now for a specific working group or for data collection that informs that would inform a cost of service study, as you know, that you spoke to a little bit in your direct testimony. And so my question is, do you think that data collection would help construct a most help in the construction of a very large load tariff?
Thank you, hearing examiner. So I think Walmart provided that testimony because we thought that that was, those are concerns we have. We have concerns about cost shifting. We have concerns about not knowing what's not in the cost of service study. And so we presented a proposal as a sort of proactive approach of giving the commission a recommendation of how to maybe protect against that or solve some of those problems. As you pointed out, the stipulation is a little bit different. We have in the stipulation, and you know, an important point for us is the large load tariff that will be implemented soon. And what we've seen in other states, so just for reference, in California, with the Rule 30 docket, PG&E came in and they proposed a tariff and, you know, make the case that what they needed to do was get the tariff established with rates and get customers taking service on the tariff so that they could collect the data. And what we anticipate is that that data with that will be made available by the tariff with new customers will inform the company's filing and their cost of service study in the next rate case. Of course, I can see that there is a bit of a lag, given just the sort of, you know, time in between. We think it's a step in the right direction, because we don't know what's absent. But without a tariff for that, we can't move in that direction. And so we think that this was a really good first step. So it's a different path, I guess, if that makes sense.
Yes, it does make sense. Thank you. And I'm trying to think. I think I have one more question. I'm just trying to. And so is the process in California that the tariff gets established and that just defines customers that qualify for that tariff, or is there already enrollment in it? Because I'm at risk of showing a real blind spot in my knowledge. I would think the tariff wouldn't have an effect on a customer until there were rates associated with that customer, so it would need to go through the rate case. So the tariff would define a group of customers that fall within that tariff into which it would apply. Those rates get set, and then there's a period of the rates being set that they're actually in use by those companies that are in that tariff. And there is when the data starts to be produced after that rate that's set in the next rate case that concludes after the tariff is established. Am I understanding correctly how that might have functioned, or am I incorrect? Do you have that knowledge?
So I'm not certain of everything that's happening in all the states. That's an example. And what I think is happening right now is Rule 30 is still an open docket. And in that, so California's rate cases for each of the major utilities are set on a 5-year rolling basis. So the Rule 30 VLL docket is actually in between rate cases, and it also has rates. So customers, if this tariff gets approved in between the rate case, can subscribe. And I believe the utility SPS or in Colorado, Excel has a large load tariff filing as well, which includes, the sort of parameters around the customers that would be eligible and also the rates. And just to be clear, because it's a monopoly utility, my understanding is that the company has an obligation to serve. And so there's just generally speaking, unrelated to these specific issues, that if, large customers show up, so to speak, at the utility's door now without a specific tariff, they still get service. And I think in this case, they might have an ESA. And so the question of, in the meantime, of where we go between now and the next rate case is continue with ESAs, or there is a large load or very large load tariff filed and potentially approved. I guess that's up for question of what's better. But we propose and support the idea of consistency and transparency that is available when you have something like a very large load tariff. So I don't think this is sort of in lieu of the customers not subscribing. It's just they would have service under this tariff versus an ESA. Or that's my understanding anyway, if the settlement were to be approved.
Thank you. And your acronym ESA, what does that stand for?
Oh, electric service agreement. I think that the company can make with the utility can make with a potential large customer.
Okay. Okay. Great. I wanted to just kind of square that up, that the information gathering that informs that construction, and I appreciate that you provided a lot of information that helps me start down certain roads to a better understanding. So thank you.
Pleasure.
Thank you.
Thank you.
Thank you, Hearing Examiner Gecko. Ms. Clark, do you have any follow-up questions for Dr. McGovern, given Hearing Examiner Gecko's inquiries?
I do not.
Thank you, Ms. Clark. Dr. McGovern, on behalf of the commission, thank you for your participation and contributions to the proceeding. You may be excused.
Thank you so much. Have a great day.
Thank you so much. Okay, everybody. Well, we're just about to 5 o'clock, and I think it's actually a very good stopping point, and we can talk about just some procedural matters that may be on the parties' minds, and look forward to what's in store for tomorrow. I will say firstly that we only have remaining now staff to present its witnesses in this case. All interveners now have presented their witnesses. We are also given the cross-exam times that were submitted by the parties to cross-examine staff witnesses. It's tentatively looking at almost about 6 hours of cross-exam time. So that may change. There may be some time that's added or subtracted, but that's what we have to look forward to for tomorrow. So I'll just pause there for a minute and check with hearing examiner Getco and also with staff and other parties here now if they have any procedural matters, thoughts, or concerns that they would like to share before we conclude for today.
Hearing
Yes,
examiner
Ms.
Schaefer.
Hardy, go ahead. Oh, okay, let's go ahead, Ms. Hardy.
I'll wait my turn. I will wait my turn. I
Sure.
apologize. Please.
Go ahead, Ms. Hardy.
Thank you, Mr. Examiner. Two things. One is I was hoping that staff could let us know what order they will call their witnesses in tomorrow so we can prepare for that. And then the
Sure.
other matter is earlier today you had mentioned moving SPS's response to bench request number 2 into evidence.
Yes, are you prepared to do that?
Yes, I am.
Okay, let's do that now briefly just before we conclude. So Ms. Hardy, you'd like to offer that into evidence?
Yes, I would.
Does any party object? It is admitted. Thank you, Ms. Hardy.
Thank you.
What exhibit number?
It's bench request number 2, Mr. Lee.
Thank you.
Thank you. I believe that's 51. It should be 51.
I believe
Has
it
that
may
been
be,
uploaded yet?
I believe it was filed and served. And I believe it would be SPS Exhibit 52 because we uploaded our application as 51, I
Let me
believe.
refresh the Dropbox. I don't see them uploaded yet, Ms. Hardy, into the Dropbox.
Okay, I can check on that. We can get that done.
Okay, Mr. Lee, we'll have those uploaded momentarily, and that would be Exhibit 52, Ms. Hardy. Bench request number 2 is 52,
I believe that's correct.
and bench request number 1 should be SPS Exhibit 51, Mr. Lee.
Thank you, Judge.
Thank you, Mr. Lee. Okay, I saw Mr. Rushoff with his hand up. I'm not sure if his question was answered. Maybe he had the same one as Ms. Hardy.
I did have the same question about the witness list order for tomorrow.
Sure. Okay. Mr. Elliott, do you have a sense of the order of witnesses for tomorrow?
Yes, Mr. Hearing Examiner. We'll be starting with Mr. Blank, followed by Mr. Zigich, Mr. Maldine, Mr. Brossi, Mr. Dunn, and lastly, Mr. Rilkoff.
I'm sorry, Mr. Elliott. Can you just say that one more time? I didn't keep up.
Blank, Zigich, Maldine, Brossi, Dunn, Rilkoff.
Thank you.
And one question, Mr. Brossi has a correction to his testimony.
Yes.
It's one number, but would you like us to upload that corrected version? It's already been, the testimony is already in the record, so we would introduce it at when we present him.
Yeah, I think we prefer to just have it redlined and corrected and uploaded, so there's no confusion. I say that also, again, not just for this particular moment, but for all instances, similar instances, because it really helps Mr. Lee keep the record straight and identify with precision what exhibits are which, and have them properly attached to the transcripts and admitted. So that's sort of why we like to be very clean about that, Mr. Elliott. But thank you for asking.
Thank you.
Okay, hearing examiner Gecko, did you want to share anything with the parties?
Yeah, just one item. Tomorrow I'm lucky enough to be presenting at the open meeting on a case that's been mine for a long time from a previous role in general counsel's office. So the timing of that will depend upon the amount of public comment at the open meeting, and that could take up to an hour. It could be much less than that. And then once the actual open meeting consideration of items on the agenda starts, I expect that I will come in about 15 minutes through that and have a 15 to 30 minute presentation with the commissioners. I'm going to do my best that to prepare this evening and in the morning too, so that if there are questions for a witness that are of interest to me, hearing examiner Schaefer may be able to handle that, though, given the way things go, sometimes I may want to say, I'd really rather stick around and hear what's said. And so we're going to have to play that a little bit by ear, and I'll be getting some information at around 10:15 in the morning that really informs me of when I'd need to take a small break. I'm going to do that virtually. I'm going to present at the open meeting virtually. And so that's just to give a little preface that we'll likely have about a 30-minute break. That's, I'd love it if it's only 15, but something of that sort, mid to late morning. So just wanted to give a heads up.
Thank you, hearing examiner Gecko. So before we recess for the day, just checking again, everybody, if anybody has any additional thoughts or comments to share before we conclude? No? Okay, well, thank you, Mr. Lee. Thank you, everybody, for your professionalism, and we look forward to seeing you tomorrow just shortly before 9 a.m., and then we'll go on the record. Thank